Good afternoon. I'd like to call to order the Delaware County Board of Elections provisional ballot hearing of November 14th, 2024. Please stand to say the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Mr. Allen, would you please present the agenda for today's meeting or hearing?
So this is the hearing to decide objections that have been filed against individuals' provisional ballots. In short, a provisional ballot is issued. It's a non-standard ballot. So if you check in and everything appears to be in order based on your registration information, and if you need to show ID, you showed ID, or if there's some other affirmation that you need to sign as an inactive voter, what have you, you get a standard ballot and you scan that into the precinct scanner. If there's a question about a voter's eligibility, such as they're not registered at all, they're registered in another county, they're canceled, their registration was canceled because of return mail and then 2 federal election cycles that passed and there was no action by the voter to respond, or there are a variety of other situations, or the poll pad indicates that the voter applied for a mail-in ballot and either has not returned it, but we don't know that they haven't returned it on election day. So their backstop, the protection that's been provided for 20 years now plus is the provisional ballot. So the provisional ballot, the poll workers issue that either by preparing a provisional ballot on the touch writer, or in some cases, taking an election day ballot and converting that to a provisional ballot. It is then not entered into the scanner, but instead returned via a provisional ballot envelope, where there are various blanks that the voter is instructed to complete, the judge of elections and the minority inspector are instructed to complete, and then they're returned at the end of the day, all those green and white envelopes in this large envelope that has all of the provisional voting return and then signed by the judge and the minority inspector. So from there, the voter registration staff has been busy since last Wednesday, initially assembling all of these and then going through them one by one, of looking through the Sure system, of checking other available records, whether it's vote by mail records or checking whether the ballot was returned, the vote by mail ballot was returned or not, and whether there is a valid registration, perhaps in a neighboring precinct, or if they're registered in a situation that we cannot count their ballot. If they're registered in Erie or Lancaster or whatever, they're not eligible to vote in Delaware County. Or if there's, if they totally did not respond to a HAVA letter, in other words, they registered maybe close to the deadline and they received a notification that their matching information, whether it was the social security number or their driver's license or PennDOT state ID, did not match. And if they did not respond to that, the registration is not complete. That's a matter of federal and state law. So there are a variety of situations. And then in the course of that, we presented the findings to a table of individuals who, for the most part, represented the Casey campaign and the McCormick campaign. And they filed the lion's share of the objections that we're going to go over by category today. So we'll go through those. If there's an individual voter here, we want to take preference of that and hear that situation, pull that envelope and examine that and decide it so that you're not stuck here waiting through all of these other categories. The first one, though, we need to consider, I'd ask the board to consider a motion to,
Sorry,
ahead.
Jim, I just want to do a couple housekeeping things before we get into the objectives. Okay. And I want to introduce, my name is Ashley Lunkenheimer. We have not a lot of new people. That's great. You're welcome to come to all of our meetings or watch them online at any time. This meeting is a little different in that it's not an open meeting. It's a hearing. And so that does require us to adjudicate certain challenges that Mr. Allen just described. And it will limit certain things that happen at normal meetings, one of which is public comment. Public comment is at the open meetings. This is I guess, quasi-judicial proceeding in the sense that we will be adjudicating provisional challenges. To my right, for those who don't know, is John McLean, and to my left is Scott Alberts. The three of us comprise the board. Because it is a hearing that individuals who make challenges, if they don't prevail, could challenge in an appeal to the courts. We do have a court reporter here. I will do my best to speak slowly, and we all need to not talk over each other so that she can record what we say. And then just for those who don't know, the individual to the court reporter's left is Manley Parks. He's the solicitor for the board. And the individual who was just speaking is Jim Allen. He's the director of elections. We'll also have presentations by certain members of our team on the election bureau, and I will have them introduce themselves at that point in time when they speak.
This is by law. The Sunshine Act, this is another meeting.
Mr. Parks, before we cut her off, we're not going to take open objections, but I was thinking about already asking Mr. Parks to address that very specific issue because I expected that people would want to understand why a hearing doesn't. Hey, we're not doing that. I will address the question. We're not doing that. Okay. Mr. Parks, would you please explain to the public?
Yes, I'd be happy to. As a preliminary matter, the people who are entitled to be at this hearing are the objectors, the voters, the candidates, and the campaigns. As a courtesy to the public, we've allowed public attendance at these meetings, although that's not even statutorily required. That's the answer to the question. If the public is not even statutorily entitled to be at these meetings, then there certainly is not an opportunity or appropriate for public comment. This is a judicial proceeding.
We're not going to play that game. You have it on recording. It's on live stream. We can look that up. Ms. Hoops, we are not going to proceed in this way. And if you continue to interfere with the meeting, I will ask you to leave. There's not calling out in this meeting. We have people here who are designated to speak from both parties who had candidates in certain races. Mr. Allen. Okay,
So-
with that, we're going to start with a preliminary objection. We have an objection that covers all of the ballots. I'll let you present that. But I do want to just say to the voter whose ballot was challenged, we are going to try to get you earlier than later. You're welcome to stay. And I don't know that we'll have decided the issue that was presented on your ballot. I don't know it yet. We'll hear it when it comes up. But we do want to make sure if you want to speak about your ballot and why you think it should be counted, we'll let you do that. Yes.
One suggestion just for good order, I think it may be useful to begin proceedings with a brief description from Ms. Winterbottom of the process and the notation of the fact that there are recommendations and that the challenges are challenges to the recommendations. So I think it's useful to put that fact on the record initially before we move on.
I think that's a great idea. And I do, and I will help you, Ms. Winterbottom, but please, if you wouldn't mind coming forward just by saying this. For each registered voter in Delaware County, the Bureau of Elections has already approved the registration and determined that the voters are qualified to vote under Pennsylvania law. Is that correct?
Correct.
Okay. And then the challenges need to be resolved under the election code. I'm going to read a little bit here. I don't like reading, actually, like talking impromptu, but I want to make sure I get the law right. Regarding the challenges for the basis of the registration, we're going to seek individualized challenges, although we're going to do them by batches. I know the objectors have reviewed each individual ballot that they've challenged, but we're going to address the legal issues in groups, hopefully to facilitate this hearing and the resolution of it. If it is determined that the individual was registered and entitled to vote at the election district where the ballot was cast, and that includes the provisionals in this case specifically, the County Board of Elections shall compare the signature on the ballot envelope to the voter's signature on file. And if the signatures match, shall count the ballot if the County Board of Elections confirms that the individual did not cast any other ballot in this election. Is that correct?
Correct.
And for all of the provisional ballots that you have reviewed, if you have recommended either a partial or a full count, have you conducted that exercise?
Yes.
Okay, with that, I'm trying to ease your presentation, but if there's, if you wouldn't mind giving a high-level overview of just the mechanics of the process for the group, I would appreciate it.
Sure. So,
Yes, go ahead.
Yep.
And please, as I said, yeah, introduce yourself
Yep.
and tell them your role, please.
so my name is Crystal Winterbottom. I'm the Chief Clerk of the Voter Registration Office. I've been in the voter registration office for 21 years, and I've been doing provisionals, I think, since 2004, 5, somewhere around there. This election for the voter registration department was the busiest that I have ever seen for voter registration purposes. And I do want to thank, we've had our teams in our other election offices that helped us, especially during provisionals, that we can hurry up and get these reviewed, which the observers were always so kind and so patient with us, and I thank them as well. We did have a little over 4,500 provisionals to review. When we review provisionals, this is whether a voter had applied for a mail-in ballot or an absentee ballot. In the poll book or poll pad, it will say that they have to cast the provisional ballot so we can make sure a mail-in ballot or absentee was not received back to the Bureau by them.
And to be clear, that's so that they don't vote twice.
Yes. Which we do have a category that their provisional does not count because it was timely received and counted by the Bureau for their mail-in or absentee.
And we see that sometimes now because people are concerned that their mail-in ballot may not have gotten to here in time, right? So
yes.
they vote provisionally as backup.
Or they were checking online and maybe the state didn't update that it was received yet. So they're thinking that their mail-in ballot wasn't received by the Bureau, so they can go to the polling place and in the poll book, they're instructed to vote provisional. So we do the review, like investigation part after election. This time we organized our materials on the Wednesday after election. And then Thursday, we started the review with our observers. That started later in the morning on Thursday after election, and we concluded Wednesday morning. The review part, all the voter registration staff is searching in the SHORE database, their name, their birthday, their address. Are they registered? Do they have any pending applications? Are they registered in a different county? Because we can see the state. And then we determine on a cover sheet on each of these provisionals if it should be a full count because they didn't cast another ballot. They are registered and voted where they should be. If it's a partial, that they voted in a different polling place and weren't on that poll pad, and we had them in a different one, we would also then categorize those partials, what is in common with where they're registered and what on that ballot should or shouldn't count. And then
So people know that. So partial, for example, if you had a representative that was in the wrong district.
yes,
Then you couldn't vote on that. If you were voted in the a district where you were not, you're receiving a ballot that has one of the, I don't want to say all the candidates' names, but
yes,
they're not the representative that you should be voting for, then you wouldn't count that vote, but you might count the presidential, obviously, because that applies to everybody.
correct.
Okay.
Correct. And then we have the category of no counts where they maybe are not registered or maybe the provisional is incomplete or no secrecy. Incomplete, we did see some that were spoiled. Everything that we get back that is filled out at the polls by the poll workers in the provisional envelope, we do a cover sheet and we send it all out to the provision or to the table with the observers, which they've seen ones that they write spoiled across it. You know, we send it everything all out if they did that. So that review part, and we attach the print screens of the voters' information from the SHORE database to the provisional that they can view themselves. If the last date voted, it shows on the SHORE screen. If they're not registered, it shows on that SHORE screen. The precinct they're registered at, that shows on the SHORE screen. So we had a little over 4,500 that we reviewed. And I do have counts. The challenge ones, we have a total of 732 provisional ballots that were challenged.
And are they all partial or full count recommendations? No,
So the voter registration office recommendation for full and partial counts together, challenge is a total of 380. Our no count recommendation, those challenges is a total of 352.
And there also are 3,000 that were not, I'm sorry, 3,800 that were not subject to any other challenge, any individualized challenges.
And I have those numbers broken down too, but for the challenge ones, it was a total of 732.
For clarification for the record, there was at least one blanket challenge as well to any full count.
To all the
Correct.
full counts. So that total is, now the full and partial challenge aren't broken up between full and partials. So that's just that number of 380. So those full counts in that pile are challenged, plus the full counts that were not challenged by
any specific objection?
yes.
The blanket object, yes.
is 3,013.
All right. Does anybody have any questions for Ms. Winterbaum before we proceed on, they think, it's really, I know you know the answers to how the process is, but anything to bring out so that she can share it with the public? Anything, Mr. Parks, that you were thinking of that might be helpful? Mr. Allen?
So the first objection I think needs to be heard because it's a blanket or umbrella challenge to all of the provisional ballots.
Thank you.
It was filed by Gregory Stenstrom. And I would entertain or I would ask that there be a motion to consider to hear it and consider whether to overrule this objection.
All right, do we have a motion? We're going to hear from you, Mr. Stenstrom, but first we're going to put it on the table. If that's the best way to proceed, is there a motion to sustain, either way we want to do it, sustain or overrule the objection of Mr. Stenstrom?
I'll make a motion to overrule the objection.
Well, I guess just procedurally, I don't
The
know
objection.
anything about it or.
No, we're going to hear it. So this is just to open it up. I guess Mr. Allen had asked to do it that way. We don't have to do it that way. We can wait. Why don't we hear the objection?
There's not, just for the record, there's not a second to the pending motion, so we can proceed.
Thank you.
I'm going to take my coat off. Thank you. One moment.
And you're lucky this won't be on a 3-minute clock as it is with public comment, but obviously, given the audience, if you would keep your comments as concise as you can, we'd appreciate it.
I'll be brief. Ms. Lincolnheimer.
Thank you.
I just have a brief opening statement and closing.
Absolutely.
Good afternoon now. I'm here as a certified poll watcher and authorized representative under Pennsylvania law, challenging provisional ballots that lack clear verification of voter qualifications. Under the Pennsylvania Constitution, the Election Code, and federal statutes like the Help America Vote Act, it is the legal duty of election officials, not individual voter attestation alone, to verify that each voter is a qualified elector. This verification ensures each voter is a U.S. citizen, 18 years or older, and a resident of this county. The reason for the blanket objection was that on the day of the first day of provisional, the challenges and reviews, Ms. Winterbottom, who just spoke, could not verify that the subject ballots were from qualified electors. And specifically, I asked, is there a V, some indication on the forms that were provided to us that indicates that the county had verified that the voters were eligible to vote? In closing, and I'll move on, but I urge the board to adhere to its statutory responsibilities under Pennsylvania law and federal mandates, including HAVA, to verify the qualifications of every challenged voter. The law is clear. Self-attestation is not enough. The board must provide assurance to the public that only eligible, qualified voters are permitted to vote. My goal here is not to disenfranchise any eligible voter, but to uphold the integrity of our electoral process. The integrity of our election process demands that only legal, qualified individuals participate. And as I stated in my challenge, I will withdraw my objections to all of them. If the board fulfills its statutory obligations to confirm these voters' eligibility, that they are qualified electors and will attest to as such. I have a few things here, just to hand to the board. With all due respect, I took a little bit of time to print out the requirements for verification of qualified electors, a table of authorities for provisional ballot challenges. And also, we have a case before the Third Circuit right now, I think as you are aware, John Child, Gregory Stenstrom, Leah Hoops, and Joyce Schwartz, that covers the issue of qualified electors. It's currently on appeal. We do expect it to be heard within a week or so. But I'd really appreciate it if I could just give these things to you, for your consideration. And that if the board, I don't know if we're going to go through things individually, but if the board will attest that these are all qualified electors, the 3,013 challenges, if you will attest that they're all qualified electors and that they're 18 years of age, they're U.S. citizens, and they reside here, or there are exceptions, or they otherwise meet the exceptions to be able to vote here. That's UOCAVA, military, and so forth. If you'll attest to that, then I will withdraw my objections and you can move on to the next part. So if you,
But before you approach to hand those up, I just want to just make sure we're on the same page, because I understood your challenge to be a little bit more nuanced than you've said today. So I do want to make sure I understand it before we can have a discussion about it among the board. So as I mentioned earlier, and Ms. Winterbottom verified, for every registered voter in Delaware County, if they're registered, we have already approved the registration and determined that they are qualified to vote under Pennsylvania law. And then the provisional ballot, which they've cast, has certain checks that she and her team, she described, put on them to make sure that they are entitled to vote at this election, and then also that they're entitled to vote in the district where they cast their, or the precinct where they cast their provisional ballot. So, and and of course, Ms. Winterbottom, definitely jump up and raise your hand if I say anything wrong. And so to do that, they compare the signature on the ballot to that on file with the voter registration. If they matched, they also confirm that the voter didn't vote elsewhere, and then they count the vote, and it's a partial count if they're not voting in the right location. So their ballot isn't correct for what they could have voted on. So all of those things, that to me lays the sort of prima facie case that a voter is a qualified voter if the recommendations come from our bureau to count or partially count their vote. And those are the basis for this. What I thought your challenge was, and maybe it's not, is that you didn't think that we could do that, make that determination of qualification by use of the SURE system, which is the system that we use to make some of those checks. Not all of them, but some of them. So I just wanted to make sure I understand your objection before we discuss it.
may I respond?
Yes, please.
I understand the issue here, your dilemma here. And there's a confusion, I think, which amongst the board and amongst the public, that a registered voter equals a qualified elector. The statutes are clear, and I have them here for you, that anyone can register to vote. An illegal alien can register to vote and so forth. And the state must, by law, allow people to register to vote. Then there's a statutory authority, and I have it right here. And it's Pennsylvania Election Code 25 PS 3050 A.4 or provisional ballot verification. Mr. Parks, I'll provide you with this so you have it. I have it for you as a courtesy copy. The statute requires the Board of Elections to examine and validate the eligibility of provisional ballots, ensuring that voters meet the state's criteria as qualified electors. And that's very specific language. As you know, as an attorney, words matter. And there's a difference between a registered voter and a qualified elector. My goal here, as I stated, is not to disenfranchise anybody. As a matter of fact, I think we're, myself and the people that are here observing this are probably the only nonpartisan, although I represent congressional candidate Althea Goodwin and U.S. Senate candidate Marty Selker. And that's how I'm fulfilling the statutory role. Our goal here is to ensure every qualified elector is allowed to vote, Democrat or Republican, Independent, Constitutional Party. So the interpretation of this statute 3050 A.4.4 is the board must conduct a substantive verification as to a voter's claim. A voter's claim or attestation is insufficient to fulfill this statutory duty. This provision confirms that election administrators heed the obligation and bear the obligation to validate qualifications beyond voter declarations. The state has already admitted, and you said it about the 1 hour and 6 minute mark in the Pat Bleasdale hearing just passed, that you cannot actually trust the voter data rolls. You said that yourself. And what I've done is to clear up the confusion in terms of a legal opinion as to what a qualified elector is. There was an open Office of Open Records request from Leah Hoops, which your solicitor or the solicitor for the county, Mr. Robert Scott, delved into in great detail, detailing what a qualified elector was. So if you'd like, I could read that in briefly. Do you understand?
And before you approach, I'm going to just say this, ask you this.
Mhm.
So we have registration has determined that the voters were qualified to vote originally at the time of registration. And then Ms. Winterbaum's job, and the one she described that she's been doing with lots of teams and assistants, that she thanked those who helped from the county government officers. They have to check to make sure that they're still registered and entitled to vote in this election. So that process has been done. So I'm going to ask you this.
No.
Do you have any individualized evidence on any of the voters of the 313 that you've challenged?
3,000.
Sorry, 3,013. Thank you.
4,500.
3,000, but you only challenged those who are counting. 3,013. Thank you. Words do matter. And do you have any individualized evidence to present to us on any of them?
The burden, again, you conflate the difference between registered voter and qualified elector.
We're going to discuss
and-
the points you've made
May I respond, Ms. Lincolnheimer?
briefly.
The burden of production on that is on the Board of Elections. There's no possible way, and this was the subject of my objection, there's no possible way that I can make that determination. Only you can. If you will attest as a group or personally that all these people are in fact qualified electors under Pennsylvania statute 3050 A.4.4 and under Pennsylvania Constitution, Article 7, Section 1, and Pennsylvania Election Code 25 PS 1329, and the Help America Vote Act 52 USC 21081, the National Voter Registration Act 52 USC 2507, and as interpreted by case law in Marbury versus Madison, Bush v. Gore, Dombrowski versus Feister, and In re Canvass of absentee and mail-in ballots, which was a decision by our own Pennsylvania Supreme Court, then we don't have a problem. And one other thing you just mentioned was the signatures. It's Pennsylvania Supreme Court that a voter cannot be disqualified. Curious, I don't agree with the ruling, but the Pennsylvania State Supreme Court has ruled that a voter cannot be excluded from voting based on their signature. So what I'm doing here is I understand there may be confusion and there's confusion with the public. A registered voter does not equal a qualified elector. And I think of the two attorneys, and there's other attorneys here present, but Mr. McLean is an attorney and you were an attorney. I brought the case law with me for your review. And the only request I have is that you verify that these people, because you have a statutory role, not the state. The state does not fulfill the statutory role to qualify the electors. We've been through the SURE databases and we've all been through the same databases. And if you'd like, you can call Ms. Winterbottom back up here. And I was tried to be respectful.
No, I appreciate. I've tried to give you a lot of leeway.
Thank you.
I'm going to run it the way I do, the way I'm going to run it. If Ms. Winterbaum's going to
understand.
come or not. But what we have, I'm just going to tell you my view, and then I'm going to move to see if anybody has any questions for Mr. Stenstrom besides what I've asked, is that we've done, Ms. Winterbaum has come up on a public meeting, on a recorded meeting that people can watch. and said, I think, and she said yes to these two questions, that for each registered voter in Delaware County, the Bureau of Elections has already approved the registration and determined that the voters are qualified to vote under Pennsylvania law. And that with respect to these provisional ballots, if it is determined that the individual is registered and entitled to vote at the election district where the ballot was cast, the Board of Election will compare, which she said she did, the signature on her team, not just, you didn't do all of them yourselves, the signature on the ballot envelope to the voter's signature on file as required by statute. And if the signatures match, shall count the ballot, or in this case, recommend to us that it be counted. If the County Board of Elections also then confirms that the individual did not cast any other ballot. I take her statement as truthful. She is a officer of this county, and she has come up here and made that statement. So I'm not going to require some separate attestation process. I find that's personally sufficient. But I will give a chance before if you'd like to hand up the materials first before we see if there's any other questions, or if you'd like to not do that, either way, I do get a clear indication that you'd like to hand the materials up. So I do want to do
May I
Quick
brief-
point.
Mr.
Yeah.
Your question to Mr. Stenstrom related to any individualized evidence, I take it from his response that he has none and he's making a legal argument. But I think that we need to clarify that for the record before we proceed further.
That's fair. So Mr. Stenstrom, just to cut to the point, not putting aside your objection, which we will discuss and rule on. But do you have any it's a yes or no question. Do you have any individualized showing as to any of the 3,013 provisional ballots that have some either a partial or full count recommendation that you've objected to?
I have a partial list here, but given that I wasn't informed until this hearing started that there was 3,013 remaining objections, the objection clearly stated that the RNC and the DNC representatives here, the partisan representatives who were reviewing the documents, I said, look, if I'm going to trust the attorneys here and to make their objections for no votes and partial votes. And the only thing I wanted to do was the blanket objection. But
well, they've made specific objections to there are specific objections to 380 count recommendations. So
right, and I don't have
that. I assume that's in the universe of the 3,013. But do you have any? You said you have.
Lunkenheimer, with all due respect, please let me rebut.
I hadn't finished speaking though.
I'm sorry. Go ahead. Sorry.
You said you have a list, a partial list. Is there any individualized evidence that you would like to present on any of the 3,013 objections, ballots that you've objected to?
As I stated on the record, there's no possible way I could have that until the hearing just now of the three. First of all, Ms. Lunkenheimer, and I will respond. Mr. Parks, although he's a solicitor, does not have standing here. I'm not addressing Mr. Parks. I'm addressing you, the board. You are the ones with the statutory duty to make the decision. Let me finish.
I need you to answer the question,
Let
though.
me
It's a yes
finish,
or
Ms.
question. All right,
Lunkenheimer.
I'll give you a little more leeway, Mr. Stenstrom, but we're
So-
pushing that leeway.
Ms. Winterbottom does not have the statutory authority to approve someone as a qualified elector. The only ones with that statutory duty is you, Mr. McBlain, yourself, Mrs. Lunkenheimer, and Mr. Albers. I'm informing you that you need to review with your legal counsel separately what the definition of a qualified elector is. If you're confused as to that, then Mr. Scott Roberts has defined that already for the county as to what a qualified elector is.
We're going to stop here. First of all, I understand our job here. All right. And we have recommendation from Ms. Winterbottom that we take very seriously. She's been a great employee of this county and does a fabulous job, but it's still just a recommendation. It is ultimately for us to rule upon.
So-
Second of all, the notion that any of us here are unprepared for this hearing is just frankly insulting. We are prepared. We have studied your objection. I've read your objections. I've talked underprivileged with my counsel. I have done my own research on this, and I am satisfied that I have enough information on your objection. Does anybody have any questions for Mr. Stenstrom? No. No. Okay.
May I
Then-
provide the material?
Yes, you may. Please provide the materials
Thank
to
you.
Mr. Parks and he can hand them up.
Again,
Ms. Hoops.
If you speak out of turn one more time, Ms. Hoops, you will be removed. Yeah, I'm just warning you that if you're going to interrupt this
Parks,
proceeding.
you are not, you have
All right.
no statutory
All right.
duty here, Mr.
Ms.
Parks. None.
Would the Park Police please remove Ms. Hoops from our hearing? Thank you.
I'll remind the board that the only ones with statutory authority in this public hearing is the three of you. Excuse me, Ms. Lunkenheimer.
You're done. You're not done. Please cut off the mic. We are done with your presentation. Please hand up the materials to Mr. Parks and we will wait till the park police bring this meeting back to order.
May I ask one question?
No,
No.
no, no. You've already talked plenty. I'll give you a chance to speak.
So here's the requirements for verification of qualified electors, a table of authorities. One moment, please. I'll give these to you. So, Ms. Lunkenheimer, may I approach?
You may approach Mr. Parks. Provide them to him.
Recess.
Yeah,
The mic, I'm not even warning.
the mic should be turned off.
I will be quiet. You tell me what law I'm violating. Tell me the law I'm violating.
The engagement only brings, I thought I was very generous in the leeway I gave the presentation. but- Thank you.
See you again.
Yep.
I objected according to the sunshine law, and I am correct. I objected, made my objection required by the sunshine law. I made an objection. Not outlined. I made my objection.
To the park police, she has disrupted a public meeting, which is a violation of law.
Public meeting. Now it's a public meeting. I thought it was a hearing.
It's the same thing.
This hearing.
Disrupting a hearing was actually.
Just sorry. Sorry, let me say that again, Ms. Loops, because words matter. It is a public hearing. It is a public hearing and you have disrupted that. That is more serious. No, you were asked not to continue to speak out of order and you did. Thank you. Thank you to the officers. I appreciate it.
This is not a sporting event. This is a judicial proceeding. And if people continue to treat it like a sporting event, they will be asked to be removed. And if they will not cooperate, then the Park Police will remove them as well. Thank you.
All right, now do we have a motion related to Mr. Stenstrom's objections? I think we should restate it if you don't mind, Mr. Alberts. State the since it was not,
The motion, you mean?
yes.
Yeah, I move to dismiss this objection.
Is there a second for the purpose of conversation?
Second.
Is there any, I've already made some comments when discussing this with Mr. Stenstrom, but Mr. McLean, do you have any comments you'd like to make regarding this objection?
No comments.
Okay, Mr. Alberts.
I have no comments other than to say, I thank you, Ms. Winterbottom and your team for the work you've done to prepare for this meeting and for all these challenges and all these provisional ballots. Thank you for the work you do to make sure that, our voter registration rolls are clean and that the people who are eligible to cast votes are able to do so.
Thank you. All right, then if there's nothing further, Mr. Parks, from the solicitor, then we can move this to vote. Okay. Then all those in favor of overruling the objection of Mr. Stenstrom, please say aye. Aye. None opposed. That motion passes. Thank you. We'll move to the next. Oh, I think at this point in time, Mr. Allen, were we going to provide the voter an opportunity to speak? If you would like to speak, and before you do though, I would appreciate if Ms. Winterbottom could present on why, what was the ruling of the recommendation of the voter registration related to your ballot? And then we need information about what was the objection, whether it was to a no count or a count, please.
Yes, so we received this voters,
Oh, sorry, the microphones are,
turn it on?
just Pat, can you tap the green? Oh, it's on, okay.
So this voter voted a provisional at his precinct where he is a registered elector. On the provisional ballot affidavit, the judge of elections marked that the voter was issued a mail-in ballot. This voter was not issued a mail-in ballot, did not vote any other way. But I'm not sure the other reason, because this voter didn't have a mail-in ballot, why they voted provisional. So we recommend to fully count this voter's provisional ballot.
Because it was also determined that the precinct that they went to cast the provisional ballot was the correct precinct for them.
Yes, Newtown won.
Did she identify the name of the?
And would you please
Yeah.
identify the name of the voter?
The voter's name is Michael Mahalo.
And so the objection to the count, that is an objection, Ms. Wagner, made by you? Okay.
The
So just-
objection, the challenge to this, it states that the voter did not request a mail-in per sure. So our short stream would show if they requested a mail-in ballot, and that is not on this voter's screen.
And Ms. Wagner, if you'd like to say something, I do want the voter to have the opportunity to hear the challenge. Yeah, if you don't mind, just so it's recorded better.
We did make that challenge initially just
Sorry,
because.
can you introduce yourself?
Absolutely. I'm Megan Wagner on behalf of McCormick Campaign. My attorney ID number is 2033357. We did make that challenge based on the fact that the reason provided was that he received a mail-in ballot and didn't receive it. I trust in the SURE system very much, and it did indicate that no mail-in ballot had been requested. I was not sure why he would have voted provisionally at that time. But if it has been Ms. Winterbottom, who I again trust very much, indicating that he was in the right precinct, I don't understand why he voted provisionally. But based on that, I will withdraw that objection.
If I may, and if you could stay with us, Ms. Wagner. This gives us an opportunity to address an entire category.
Oh, can I then keep her nearby? Would you stay nearby? But I want to just explain to the voter what happened.
Absolutely.
Yeah, okay.
By nearby, you mean up here?
Yeah, just, you don't have to go all the way back to the back of the pack. Okay, I'm sorry. And sir, would you please come forward?
And while we come forward, do we have any idea what number this is?
Oh.
Yes.
To the,
299.
it's, yeah, if you go to the third to last page. I apologize if you number these pages.
Sir, I just want to make sure you know, you may very well know what just happened, but I just want to make sure that you know, because you don't have to present or you're welcome to, you're here and we appreciate you coming, is that for whatever reason, it sounds like, and Ms. Winterbaum, correct me if I'm wrong, on your provisional ballot, it indicated the reason you needed a provisional ballot was that you had requested a mail ballot. The SURE system showed that you had not. So there was some confusion. And I think Ms. Wagner said that's why she objected, because it didn't make sense that that would be what was written on the provisional ballot when it didn't appear to be true. I don't know if you want to provide any information about that, but I can say that the objection has now been withdrawn. So if we accept, this goes into the category of now unobjected to recommended count votes. So I expect that we will likely vote to count your ballot. But again, you have the opportunity. And if you do want to speak, please introduce yourself by name and your precinct.
Okay, is this on?
Yes.
My name again is Michael Mahalo, and it's Newtown Square, District 1. And just for information, I understand there's no issue here, but I had originally been on the to receive a mail-in ballot, and I had contacted whoever you contact to change to not be a mail-in ballot. But I then received information, an email on October 1st that said the mail-in ballot had already gone out, or it was too late to withdraw it. So that when I received it, I should just destroy it, and then I would be able to vote in person. But when I went to vote in person, they said, well, you have to provide us with your mail-in ballot so that we can, and of course I didn't have it because I was told I could destroy it. So that's why I had to vote a provisional ballot.
If you see, oh,
Did receive the mail-in ballot.
I understand,
And
I understand.
took it with him to the polling place. And
That's
they
good.
said that it didn't count because he didn't have the envelope.
I actually appreciate that clarification, but you do have to say your name and your precinct just because you spoke on the record.
Cindy?
Cindy Mahalo, Newtown Square, District 1. I was with him when he voted.
The reason although normally we want to keep it in order, as you can tell, Ms. Mahalo, especially for the court reporter, but I was a little confused, frankly, as to whether you had received the mail-in ballot. So I do appreciate that additional bit of knowledge. Yes.
So to your point, it was canceled. It is in the, and it's open to the public to access the entire mail absentee ballot file for all of Pennsylvania. And if you look up Michael Mahalo, it'll come up as canceled based on your request. Now, to your second point, even though you did receive it, if we had received it back, it would not have been accepted. It was already canceled in the Sure system. So in the event that you canceled it because, for example, it never arrived and you said, I want to vote in person instead. So there is that safeguard there. Now, I'm assuming that's your wife who?
Yes.
Okay. I did. So to Ms. Mahalo's point, it was poll worker error. They should have accepted both the ballot and the envelope and given you a standard ballot.
Well, I didn't have the envelope with my name on it to give to them because I had destroyed it as I was instructed to do.
Okay.
Okay.
So yeah, the poll workers are instructed by law to issue a standard ballot if and when the voter remits or returns or submits their ballot, whether it's marked or not, and then the barcoded envelope. So
it was really an error to send me an email that said that you should destroy your ballot.
For whom was that?
that was not the only thing that has caused this issue is that there was an objection. I mean, we were ready to rule your provisional ballot.
I understand.
To count.
But I think you were saying that the poll workers should have allowed me to vote.
If you had had your return envelope, it sounds like based
But
on what you.
how would I have known that I should have had the envelope with me?
He's saying he was told to destroy it, so he would not obviously have the envelope if he was.
So I'm suggesting that the email that came out that said, we canceled your mail-in ballot, go ahead and destroy your ballot was in error to send that, right?
No, it was not an error, but what was
No?
an error is somehow are still flagging that as needing to return that ballot and
Okay,
envelope.
so that's the error.
That's where
That's
the
the
error
error.
Okay.
Chair, would it be proper at this point, just to sort of cut to the chase, to I'll make a motion to dismiss the objection to Mr. Mahalo's ballot and approve his provisional ballot, accept it and approve it.
Know if the motion to dismiss is necessary, though, because it's been withdrawn. So you could make a motion to accept the recommendation, but it sounds like to me, based on the way that the Stenstrom objection was handled, that probably there will be a motion at the end once the various objections are addressed to adopt the recommendations with respect to any ballot, and so I think that would probably be the time to
My
do it.
only point is Mr. Mahalo's here
Sure.
so that he doesn't have to suffer through the rest of this meeting.
There we go. Let's do it. Let's vote on Mr. Mahalo's.
So that he
ballot.
knows his vote counts.
Is there a vote to accept the recommendation to fully count the vote of Mr. Mahalo?
Yes, moved.
Seconded.
Thank you.
Those in favor say aye.
Aye.
None opposed. That motion passes. Thank you
Thank
very
you.
much for attending and sorry for the confusion, but thank you. We have a lot to get to.
I'll take 1 minute.
Go ahead. As a courtesy, go ahead, but then I'm going to have to stop extending courtesies from here all night.
It makes me very uncomfortable to hear that your Sure system showed, what did it show?
Canceled.
It had the correct information.
It sounds like it didn't. It says your Sure
well-
system said that no ballot had been sent. The ballot had been sent and then it was canceled. And then the envelope was destroyed. So why was if the poll worker correctly did not accept the ballot because he didn't have the envelope and then gave him a provisional ballot as they were supposed to do, and he voted per their instruction, then what went wrong in the system? Why did that not get counted?
How about this? Because I want to make sure, unless you know definitively, we can follow up with you in writing because there's just little bits of information. I want to make sure procedurally we don't get anything wrong and you certainly can get an exact full answer to your scenario.
We'll certainly look into this, but the email that's being referenced is issued by the Department of State. There are certain things that we're going to be bringing up after this election with the Department of State, especially with the wording of what ballots have been received and because right now they have language that says record ballot returned, which many voters mistakenly think is the ballot was returned to them or something like that. So this is one of those things where the Department of State sent out an email. I'm not sure that it should have said destroy this, but it should have just said this is canceled. It can't be counted. So, you know, I can look into that with the Department of State. I can't answer for the emails that they sent though.
But please do, if you want, if that doesn't satisfy you, feel free to email us and we will write a longer explanation of what happened. All right, with that, I understand from Mr. Allen that there's a category of ballots that may have a similar circumstance that we could address.
Yes, starting with item 298 through 305 on the list before you, there are 8 items there, including the one that was just withdrawn, where the objectors stated that there was no mail ballot application. So I just want to go through that list. So the first one, Pittman.
Are you prepared? Do you need to get anything for your, I did ask you to stay here. Okay.
No, and I don't want
No,
to
that's
make you
fine.
go through all of that, Mr. Allen, if we don't need to. If Ms. Winterbottom can, and I want to make it clear why we did that. It's because when we have the printout from the Shore system, we know where to look to see if a mail-in ballot was issued or not.
Sure.
So that's why it was done. It did look confusing. It did seem like something was off. So that's why we objected. If with Ms. Winterbottom, and I'm sure she can say that all of those, I think you said it's 8, right?
Yes.
If those 8 were in the district and precinct that they were supposed to be, and therefore should have actually been able to cast a regular ballot, I will withdraw them.
Ms. Winterbottom, these are ballots 298. We've already ruled on 299 and then up through 305 on the spreadsheet.
That was, just for the board's clarification, that was not part of the objections you filed, whether or not they were in the correct precinct. There were others that you did object to on that
No.
basis, but
I understand
none of
that.
these were.
My point is that if they were in the right precinct, district and precinct, then they would have been able to vote anyway if, you know, being that the mail-in ballot was not sent out. So that's why I would agree with withdrawing them.
Okay.
So with 1, 2, 3, 4, 5 of these, you'll see I added the response in there that it's not, these voters' records are not in the statewide file. There would not be, so it could be that the judge of election in that case checked the wrong box on the envelope as far as the reason goes. So they're not, and there's no basis in my mind to not count those 5 individuals' ballots.
Which is why I'm okay with.
Not in file, is that the 5 you're referring to?
Correct.
Why don't we have Ms. Winterbottom? Do you have, can you speak to these votes as Ms. Wagner has asked to make sure we're on the same page? Because she's considering withdrawing the objection.
If I can get those, like if you want me to pull those out.
And it seems like Mr. Parks, for process, if we're going to use this spreadsheet by numbers and not name every voter on the spreadsheet, we'll probably need to submit this.
I do not have that spreadsheet. Jim has that.
Okay.
Thanks.
298, 305.
Do you want me to pull these ones and take a look at them? File.
Well, let's see what will resolve this the fastest. I thought we were going to, you think you're going to have a quick resolution?
Point of order,
Yeah, go
Madam
ahead.
Chair, I mean,
Go ahead.
we're kind of, to me, doing this backwards where we're speculating about what could or should have, you know, if ands and nuts were candy and butts over the Christmas we would have. I mean, can't we just have the person whoever's the objection, state the objection? And then I would think in 99% of the cases, Ms. Winterbottom would, you know, testify to say whether or not it is correct or not. And then we just interpret the law, you know, around it, whether it's a valid objection or not. But I mean, I don't know. I just.
No, that's what we were trying to do. It's just Mr. Allen noted that the one we just had that was individually withdrawn was applicable to 7 others. So we were trying to start with that one.
So for here, you know, I just, Ms. Wagner, she stated the reason why she objected. I would think it would be proper to, just as a point of procedure, have Ms. Winterbottom respond
Right.
And then we make a decision on it.
So the stated reason was, I thought that's what we were doing, but no mail ballot application. And then there's some that say not in filed, some that say canceled, some that say pen not returned. But the primary objection that you had made, and and maybe it's not going to work well this way because if you don't have the same spreadsheet.
I don't.
So why don't we do this? Why don't we not proceed that way with these 8? We'll get to them.
That's fine.
And if you want to proceed orderly in a way for the objections as you intended to present them, we'll just need to make sure we match them up with what we understand to be the voters.
That's perfect.
Okay. All right. So we'll get back to that, Ms. Winterbaum. Sorry. All right. So
The next objection is similar to the blanket umbrella objection that was dismissed. And that was filed by John Child about the shore system and proving residency.
is Mr.
That was to one voter, Betty Oliveira.
Is Mr. Child here to present the objection?
I move to dismiss the objection.
Yeah, if no one's here to present the objection, then we have a motion to dismiss. Is that motion seconded?
Seconded.
All those in favor say aye. Aye.
Aye.
That motion passes.
The third item is an objection that the Joe failed to select a reason that was filed by Laura Lewis against the provisional ballot by Patrick Turbot.
Is Ms. Lewis here to present the objection or somebody presenting on her behalf? Ms. Lewis, you are here. Please come forward and state your reasoning for objecting to Patrick Turbin's ballot, which is listed as number 3.
At the provisional,
Wait, sorry, can you introduce yourself for the record, even though I just called you by name?
Gardner Township.
Thank you.
I was just observing and I noticed they were objecting when there was no reason given for why there was a provisional ballot. And so one hadn't been objected to thus far, so I just wrote my name on it because I had seen many others had been dismissed because there was no reason.
Okay.
This, the Republican Party went back after a time and withdrew objections, all the objections based on this criterion, as well as inactive voters. So this is the only objection we have like that now.
Do you have an individualized showing that Mr. Turbot, it's been determined by our election or voter registration bureau that Patrick Turbot is qualified to vote in this election and that the provisional ballot is recommended as either being counted or partially counted. The judge of elections failure to state a reason on the provisional ballot envelope, I don't believe is a reason to disqualify the voter. Do you have any individual?
No,
Evidence.
I just was doing it based on what
Okay,
I understood was a.
Would
legitimate objection.
you like us to rule on it as presented or would you like to withdraw it? Either way is fine.
I can withdraw it.
Okay, thank you.
Thank you.
Okay, thank you.
The next category is a variety of items mostly by Donna Cantor and Cheryl Loosely, who were the challengers. And this had to do with the date of the registration app was not in Sure, or words to that effect.
Good afternoon.
Good afternoon.
Donna Cantor, bar ID number 61837. I'm here on behalf of the Delaware County Democratic Committee and in conjunction with the Casey campaign. So we filed a lot of wholesale objections for non-registered voters. We have since submitted further documentation reducing that number down to 117. And that is based upon the Casey campaign doing substantial research to determine whether someone was registered or not. I'd like to hand up the documentation that they have provided. And we would like the county to do some further research for those individuals. There's a couple reasons for that. One of which is because the short system was overwhelmed at the end. There were a lot of people who had registered who we in the county didn't know had registered, which is why the Joes and the staff were instructed to contact the county on the day of the election. There was problems getting through, people were sent away, other people were allowed to vote provisionally. It turned out through Ms. Winterbottom and her staff's work that the majority of those people, I'd like to say majority, I don't know the actual number, actually were registered and the county treated them as being a full counts or partial counts, depending on whether they went to the right precinct or not. In addition, we were getting calls in our boiler room from people specifically in Yaden who had always voted in Yaden, who were being told that the Shore system said that they actually lived in Philadelphia. So we know that there was confusion for voters from different areas. So another reason why we wanted to go ahead and check with the Shore system and verify. The law is really clear on this, that you can go back to where you voted last if you do it within a certain period of time. It also allows you to go ahead and register where you are actually, vote where you are actually living for the same reasons. And I've got case law on that for you. But before I begin that, I do have extra copies of the letter that Ms. Chauncey supplied to you, I believe, on November 11th.
I definitely have my own copy here, I believe, but you're welcome to provide them. Now, I just want to make sure we figure out how we're going to do this. So of the 352, that number's reduced to 117.
Correct.
Mr. Allen was had us proceeding in categories of objections. So like objections would be treated in a like way. I don't know if there's a way, if we need to match up and say, for example, this category of 5 is in the group that's been withdrawn, or if it's scattershot and some are, and there's no way to.
I can't answer that because I do not have Mr. Allen's spreadsheet where I can go through and match up a person to a number.
But it sounds like, did you have them in any way batched by your objection to them?
No, they're simply all registration issues. So anybody who was not registered in Shore, the initial count was 352. The Casey campaign has pulled that number back to 117, and all they're asking for is further review on those issues.
We were.
Yeah, please.
It seems that the bulk of the rest of the objections seem to be from attorneys for the two parties, to the two parties.
Yeah.
If we could give them this sheet, because I don't know, I didn't get Ms. Chauncey's November 11th, and I know just before the hearing today, something was sent around, but I didn't read it because it's not part of the evidence. So I would suggest that if, we give them this, and both parties, if we take 5 minutes or 10 minutes, they can go through it. And if they want to withdraw objections, to withdraw the objections.
I think that's a great way to proceed.
Are there any pending challenges from folks who are not in that category? Or is it?
No, they're going to go through the whole list. Unfortunately, it's not going to be.
What I'm saying is,
Down as best as we could. I mean, there were even variations. They weren't even this consistent. So we logged down and I tried to provide the board with categories based on the handwritten notes at the bottoms of each of these envelopes.
what I'm just asking is, I mean, I totally get what Mr. McLean is suggesting, and I support it. Are there people who don't fit into the category of who we're talking about, whose hearings we can hear in the meantime?
Yeah,
Or is that all?
The only objectors I don't recognize are Joseph Mancano.
There's someone named Lorenzo.
Is Joseph Mancano here?
Lorenzo is here. Mr. Mancano, I believe, was working with the McCormick objectors. It just appeared that way based on objections to full and partial counts.
So then if all the remaining objectors are affiliated, let's recess and let them.
I mean, the ones we could do are the McCormick campaigns, but at the same time, we need them to validate with Ms. Cantor the withdrawals. So then if we all agree, then we'll stand in recess for, what is it? It's 1:10. So 1:25, 15 minutes. I mean, because there's not an alphabetical order. I'm just warning you, Ms. Cantor and others, this is not an alphabetical order. Do you have extra copies of these, or are we going to be using? Yeah, you'll get some. Okay. Okay. And should they come down to where would you like them to do that? Okay.
Okay. I just wanted to explain the 3 different spreadsheets that I handed up.
Okay.
Okay. Because I'm actually going to step out for about half an hour for an emergency hearing.
Right.
So match 1 were the rejected registered tab 1, where the Casey campaign compared them to the state party, and they were all registered under the state party as being registered in their precincts. Tab 2, there are 3 voters where they found them and they should be counted. And tab 3 is where they believe the voters are matches, but it's up to you to figure out whether they registered in time and whether their registration should count. So that's why there are 3 different spreadsheets, because the Casey campaign looked at different sources of information to compare the numbers.
All right, they're not called by their tab. So tab, match 1 is tab 1.
Correct.
And that is, sorry, say it again, just so we're clear.
Those are all individuals who were reviewed as registered in Delaware County or had a pending registration in Delaware County.
Okay.
Tab 2,
Just for the record, based on what? Shore system data harvested immediately?
it was the 141-page document that we obtained from the state showing all the people who had registrations pending in the state of Pennsylvania. So that was what this list was culled from, that 141-page document.
And these are the 117 that you're going to maintain objections as to.
Correct.
Okay.
And do you have any individualized evidence that any of these people you're asserting that they are registered to vote?
We believe that those people are registered to vote. We're asking the county to follow up because, one, we need to make sure that, yes, they're registered. If they're not registered, whether they moved within 30 days and still should be entitled to register. I'm still be entitled to vote here in the county. Those are all things that the Secretary of State and the federal law allows people to do. So we don't have that evidence. We can't call that evidence for you. We can't provide it because we don't have access to all the records. The Shore system and the work that Crystal did and her staff did helped tremendously, but we were still able to find at least 3 people who were qualified to vote on that day out of the 117, just with the information that we were able to find. So
That's this list of 3.
that's the list of 3, which, correct. And then match 2, the 3rd tab, is the low confidence. It's really not low confidence. It's that they simply couldn't find enough without accessing your internal records, meaning the state's internal records, not our internal
This
records.
should be 114 or there's some, no, it's not though. Everyone else is in between confidences?
Correct.
May I ask a question?
Yes.
Mr. Chair, I'm just trying to, I'm not privy to. So your match 1, are these people that cast provisional ballots?
Yes, in Delaware County.
And they were not counted?
Correct.
And you're
Recommended.
challenging the not counted?
Correct.
Okay, and what evidence do you have that you're going to present that it should be counted?
The Shore system found them in the system as pending, or we found additional information about the voters having been registered and acknowledged through the Democratic Party's website and database system. So that is,
You're going to present that evidence here?
again, I have no individuals coming in today to testify that, yes, I am registered. Because we were dealing with the blanket issue of whether we should be looking further, and that was a legal issue, not individuals. We had so many people who were turned away and so many people who filed provisional ballots at this election cycle more than any other. Crystal had provided us all with the list of provisional ballots. There was 4,533 initially. We're down to 700 and some with the work that the parties did, the work that Crystal's office did to verify that many of those people who were being challenged shouldn't have been challenged. We keep reducing those numbers as more evidence comes forward.
I guess the question though, I mean, you say you don't have anyone here to testify, but do you have you said additional information from lists maintained by the Democratic Party. Do you have that information that you used?
I'm sure we can provide it. I do not have it.
Okay, well, we can get to that after we recess and come back with the.
Or I know you have to go to court, but is your colleague able to stay and work through reducing the list?
She
with
will
the
be.
Republicans as well, so that they can have bipartisan reduction of the list? Okay, that'd be
Yes.
great.
Okay, does
All right,
that
thank
help?
you. All right, we stand in recess for, now we'll do till 1:30. Thank you. Call back to order the November 14th, 2024 provisional ballot hearing after a recess. During that recess, I think we made some progress on the 732 challenges, and we're going to start with Ms. Cantor and discussion of the 352 no count challenges that the Democratic Party has made, correct?
Thank you. And thank you for your indulgence in allowing me to cover my other hearing. So I understand that great work was accomplished in my absence, and the Democratic Party is withdrawing the three names they provided under tab 2, Simmons, Mason, and Maxwell. In exchange, the county is going to do one more check of the remaining 114 names on match 1 of the document we provided to see whether anyone else should be counted or is capable of being counted. And so that would resolve that issue on our end. We just want to have those 114 people double checked.
And just so I can make a couple things clear on the record, generally categories, you have two types of objections. One is objections to voters who are listed as pending in the registration. That's the ones that are reflected in this list.
That is my understanding.
And then the second category is a poll worker error, and you're going to preserve those, and we'll hear argument shortly on those.
Correct.
And then also, just to be clear, the 114 that will remain on this list, because the 3 are also on this list, they're going to be withdrawn. They will not, it's possible that some of them were not objected to. And if that's the case, then those would be mooted. Whatever we rule, they would otherwise be mooted because they were not actually officially objected to.
That was my understanding as well.
And then the third part is while Ms. Winterbottom has agreed to continue to check the 114 one more time, although that they have been checked, you are not presenting additional evidence on them today, and you recognize that we are not holding open the vote or the ruling on those. It's just something that you'd like to know afterwards to make decisions to appeal, and we always want to get it right so that she's going to do that second check.
That is my understanding as well.
Okay. And that you have, you're not going to present, other than the evidence you stated earlier, or the argument you made earlier about these 114, you're not going to present individualized evidence on any of them.
I am not.
I'm guessing I know what you're struggling with. Then we're not holding it open. Nothing will change. They would have to appeal. But please ask any questions you have. That's
Well, yeah, I think I understand, but I mean, when we say we're going to double check, I mean, these are, we've already checked. I don't know that the code provides for sort of a double check. I mean, nothing would have changed. I mean, people that were registered as of the cutoff date. And I guess this is more of a question to Crystal. People that would have be registered by the cutoff date, nothing would have changed between now and then, or then and now. Isn't that right? I mean, there's no more registrations that are added during this period.
So if there's a HAVA notice or a missing info letter that came after the deadline, those would be accepted before Election Day. Missing signatures would not. Those on those letters say the last day to turn those in or upload your signature is by 10/21. On the last day, we received so many on-time applications, say Villanova and our dorms, you know, we were sending out letters, calling them, emailing them. We were still able to take that because their application was on time with a signature that was in the whole app was valid.
Right, but when your staff did the check for the provisional ballots, when you brought, for each of the provisional ballots, you brought them up on the Shore system. These individuals were not registered to vote at that time.
Their application has not been approved.
We don't think anything's going to change. We think Ms. Winterbottom got it right. And I guess there's multiple ways to do it. They could do it by a right to know or some other way.
I think a more helpful way to think about this is perhaps to say not a double check, but that our voter registration staff will work with the objectors to get them access to the records for the next stage, should they choose to appeal based on, if this board rejects the challenge. I think that's a better way to think of it.
Yeah, if the matter's still open and they appeal, that's one thing. But I mean, to be fair to everybody, I guess, I mean, it's, we have these lines, and
Yeah, I absolutely agree with your view on that. And I think this hearing, there needs to be an adjudication of the issue, and it sounds like there will be. And it maybe just the way to think about it again is that there will be an adjudication, and depending on that adjudication, we've committed to allow them access or assist them with access to the sure records.
Election code gives them access.
Exactly.
I said it inartfully. Sorry, this was a fast moving thing.
So we're not holding up our decision.
We are not.
Waiting for a double check.
And no one's
That's-
asking us
okay.
to.
And I guess my only question, it just, once again, I'm sorry, there's a lot going on. The third spreadsheet, the match two projected pending VR low confidence.
I would simply focus on the first spreadsheet
Okay.
and ignore the second and the third for your
Okay.
purposes. So they were follow-up evaluations done looking at other databases.
So therefore, would be, as I understand it, a motion to dismiss any objections to the determinations made on these three sheets,
Is it dismissed or overruled?
dismiss or overrule,
Well,
whichever you
we've
like.
been using the other one.
Okay.
Okay, is that is where we're at, Ms. Cantor? Yes.
Okay.
Sorry, Mr. Parks, did you have anything you wanted to say?
No.
Okay.
Okay, then I'll second that motion.
Is there any other questions or comments on that from anyone? All right, then all those in favor, say aye. Aye. That motion passes. Thank you. Now, I think at this point in time, though, you did have three categories of objections that you will retain and you would like to present argument on.
That is correct.
Okay.
So we have, these are all work based on poll worker error, not based on voter error. So what we have are provisional ballots that were rejected because there was no secrecy envelope. That's clearly a poll worker issue. If the person wasn't given a secrecy envelope, they wouldn't have known to put one in the outer envelope. And there were many, many that fell into that category. And again, I would argue that that was poll worker error.
Can we focus on that for a little bit? Are you
Sure.
going to move to another argument or?
No, I can work on that.
I would like to hear more about that.
The election code is very clear that the poll worker's job is to instruct the voter on how to complete this document. In fact, what's supposed to happen is when someone is issued a provisional ballot, the very first thing the voter should be doing is filling in section 2, saying, I certify that I'm allowed to vote in this election and I'm in the right place and I have all the authority, fill in their address and then sign it. Then the Joe is supposed to hand them their provisional ballot. Then the voter goes and completes the provisional ballot and then puts everything back into the envelope and hopefully into a secrecy envelope if they're provided one, bring it back after they sign box 4. Then the Joe and the minority inspector are supposed to sign and date the document. So the voter has no control over what the voter is not given. And if they were handed their ballot and their envelope before they signed anything, how would they know that they were supposed to complete that? They were handed their ballot, they were told to go and vote and complete it and come back, which is not the process, which is why this is poll worker error and not the voter error.
And there are three types. So I made you go to the one.
So,
No, yeah, because I now see how you're interrelating them. So let's go through it. Yes.
so the first one is there's no secrecy envelope.
Mhm.
Okay, so if a voter is not given a secrecy envelope, they aren't going to know that there should be an inside envelope protecting their ballot. That's not something that they would know. Only the Joe should know that there should be a secrecy envelope and should be handing it out with the ballot. Okay, so the secrecy envelope is really totally out of the voter's purview. They have no idea. Okay, they only do what they're told to do when they're there, which is why we're arguing that this is all poll worker error. Okay, similarly, if they're not told to sign part 2 before they're handed their ballot and just to sign and return, I don't know that that's an explanation enough for a voter to say, oh yeah, you have to go back and affirm that you have the right to be voting. You know, there's not enough information there. There's nothing on that page, on the envelope itself that says, voter, you must sign this before you do this or do that. And the Joes weren't telling voters there's missing information. All of this is supposed to be done under their guidance. And if they're not looking at it and saying, oh, just like when we put the ballot in the scanner and the scanner has the ability to shoot back out the ballot and say, up, you overvoted or undervoted, that's a check for the voter. When we hand in a provisional ballot to the Joe should be looking at it and making sure everything is correct and then signing it and having the minority inspector sign it. That doesn't always happen. We've argued this in the past and we've been successful when only one has signed it. Because it's totally out of the voter's control.
I want to hear about, so I wanted to see if you wanted to do all three first before I speak about that number two. So,
Okay.
but yeah, because
So I sort of
please.
jumped them all together for a change. So the third issue was missing the Joe or the minority inspectors, signatures and dates. So you've got no secrecy envelope. You've got the voter didn't sign in box 2 and in box 4, part 2. And part 3 is the Joe and or minority inspector did not sign and date the envelope.
And so I want to start with just 2, just because I think I was the only member of the board at the time that 2 was litigated. And I voted in favor of your position. And I believe that the court, Judge Whalen, did not agree with me. And my colleague who also voted in favor, I think it was a split vote. Mr. Parks, is that correct? Do we have in this forum, because you did, Ms. Cantor, indicate that you've had some success with this argument. I don't know if you're talking about whether you had it with the board or in the courts, but I think we have not had success with it.
That is correct. So, my best recollection of this was in the spring of 2021. There was a close race and questions the board's policy, which basically was a slight modification to pre-2020 policy at that point, was that one signature, the normal form contemplates the voter sign in 2 places. I think it's boxes 2 and 4 from memory, but I'm not 100% sure about that. The policy prior to 2020 was if there was and Crystal can correct me if I'm wrong on this, but was that if there was a signature in either box 2 or box 4, it would be a recommended count, and the board had regularly counted those. I revisited that and based on some case law in Pennsylvania determined that there really had to be a signature in box 2, which is that declaration of the voter box. That without that declaration, there was a pretty fundamental statutory shortcoming with that provisional ballot. And so I had clarified the rule would be that if there was a signature in box 2, but not box 4, so only one signature, and it's in box 2, that could be a recommended count. That was challenged and that matter was then litigated with Judge Whalen. Judge Whalen ruled that there had to be a signature in both box 2 and box 4. And since that time, here in Delaware County, we have been following the edict of that ruling as the governing law for this in Delaware County. And that was the basis of Crystal's recommendations, at least as to this issue. So I have explained publicly that I feel constrained by the court's ruling and that we must honor that court ruling. And it's not for us to, pretend we're on an appellate court and ignore it. Now, if appellate court says that ruling's wrong or issues a ruling that's fundamentally inconsistent with it, then that's something that we would have to consider. But to my knowledge, there is no such case since Judge Whalen's ruling on this point. So that's where we are on that issue.
And did you want to say something?
Well, I thought I did kind of brush up because I know there were a flurry of Supreme Court cases in the last month or so.
Yeah.
Before, and I wanted to make sure I understood myself. I'd say there is the case in Ray Walsh where I think the court looked directly at this and said that when it deals with 25 PS 3050, the section that talks about a provisional ballot shall not be counted if. Right. And the Supreme Court has said, these things are mandatory. And either the provisional ballot envelope under Clause 3 or the affidavit under Clause 2 is not signed by the individual, a provisional ballot shall not be counted. And I don't know if you would give me a minute.
I have extra copies of Walsh if you need it.
You know,
I mean, I think we're bound by the Whalen decision, especially if you're indicating that that's been a.
yeah, but I think the Supreme Court.
Is more, yeah, even, and that'll be up to, I think, them if they decide to appeal this. I mean, I'm inclined to say that we lost in the court where we have a decision directly to this board. I was on the board at the time.
Yeah, I mean, I looked at it, I mean, I think, and I certainly, you know, Mr. Parks is the expert here, you know, but that's a different one.
If I may, just, there has been subsequent case law, not necessarily here in Pennsylvania, but the issue has been made all around the country. Neoch versus Husted, it's Neoch versus Husted. It's a Sixth Circuit case from 2022, which is after Judge Whalen's case. Where they specifically found that where poll worker error causes ballots to be marked deficient, those ballots must be counted. And although Pennsylvania courts have held that requirements to sign provisional ballots or to place those ballots in a secrecy envelope are mandatory, see in re canvass of provisional ballots in the 2024 primary election. That's from PA 2024, 322 A3rd 900. And then also in re election in Region 4 for Downingtown School Board Precinct Euclid 1. That's at 272 A3rd 993, also from 2022, which addressed the secrecy envelopes and said that the courts did not consider the due process implications of disenfranchisement due to poll workers' failure to properly instruct the voter. So we've had subsequent cases beyond Judge Whalen's case. And we've also received through the state further guidance on how to handle these things. So I really do believe that just because Judge Whalen ruled in this favor, things have changed, and the state has recognized changes because they've updated their regulations regarding this. And so, yes, while we're normally bound by precedent, we've got regulations that tell us otherwise at this point. And if necessary, and it goes up on appeal, I think the likelihood of being overturned are great because the rules have changed. We're not operating under the 2020 rules, and we're not operating under the 2021 rules at this point.
Yeah, but counsel, I mean, you cited the case, in re canvass of provisional ballots in the 2024 primary election. One of the four issues in that case was whether or not a ballot, a provisional ballot without a secrecy envelope could be counted. And the Commonwealth Court ruled specifically that it can't be counted. I mean, that's not Judge Whalen from 2 years ago. That's the Commonwealth Court on July 1st, 2024, which you just cited.
So what I can tell you, Mr. McLean, is that with this current election cycle, this issue is still being litigated, and many counties are already counting all of those provisional ballots where there is no secrecy envelope. Westmoreland and New York are doing that. They're also counting provisional ballots lacking the Joe or the minority inspector signatures, Allegheny, Berks, Bucks, Cambria, Center, Dauphin, Montgomery, and York. And there are counties that are counting the provisional ballots that only contain the voter signature one time instead of twice, are Westmoreland, Montgomery, Bucks, and Allegheny. And in fact, I think Westmoreland and one other county have since determined that they don't need any signatures and they're going to count those ballots. But again,
in direct violation of the Pennsylvania Supreme Court's rulings.
I think because the Pennsylvania Supreme Court's ruling did not address poll worker error, they addressed the law itself and not the impetus that the poll worker is the one that caused the problem,
And do you have
not the
any
voter.
evidence for any of these people that it was poll worker error rather than the individual error?
I think if you look at the statistics that Ms. Winterbottom provided us and you go through each one, if you have 24 from one precinct and all of them were denied because there was no signature, then yes, that's poll worker error. If you find a precinct where there are 24 of them and 12 of them were denied because there was no poll worker signature, I would say then, yeah, maybe you have an argument. But without that statistical knowledge, I would err in favor of the voter who has the right to vote and not be disenfranchised because a poll worker made an error. That's why I think it needs to be.
Can I ask for some clarification on one point? How many ballots, if any, and what specific names of the voters are involved are in the category that where there's a recommended no count because one or both poll workers didn't sign it?
I need a few minutes to look at
Because
the chart.
I don't think there are any.
I believe that there are.
I don't think so.
Well, and
Hey,
Well, there,
we have decided as a board with a split vote to count those in other contexts. And then since then, the Department of State has issued guidance to count those. So I guess my question for you, Mr. Parks, and we can take it into executive session, but it'll be the same question for all 3 points, is what I hear Mr. McGlane saying is, I know that Judge Whalen found against me. I wanted to count those votes. Okay, in the one category of the 2 and 4 signatures. And I think what you're saying is, hey, it's not just Judge Whalen anymore, it's the Pennsylvania Supreme Court. Either way, at least I'm inclined that we're bound by it. But if we're bound by the Supreme Court, then that is a bigger bound than by the Judge Whalen. So that's the first question.
They're sort of equal as far as the sport's concerned.
I know, but I took them as equal, but he wanted to make the point. So either way, I'm ready. I can solve it for me personally, unfortunately, with just the Judge Whalen decision, which was disappointing to me because I had made a different vote. For the second category of the secrecy envelope, Mr. McGlane, I think, is making the point that is also decided by the Supreme Court and bounds us. Whatever Judge Whalen may think on the issue, it's the Supreme Court here that we're dealing with. Is that correct? And if you don't want to do it in open,
I'm happy to refer to the statute, and as almost always the case, if not always the case, Mr. McGlane is right on point. This is 5 Romanet I, Romanet 2, and it states notably, a provisional ballot shall not be counted, and then it lists various sub scenarios. One of them is specifically states a provisional ballot, if a provisional ballot envelope does not contain a secrecy envelope. Now, there is absolutely case law, and it is longstanding in Pennsylvania, that poll worker error cannot disenfranchise a voter. I think what this board would want to consider is there evidence, sufficient evidence in the view of the board that a failure such as a lack of a secrecy envelope was due to poll worker error, such that you could carve out the equitable exception to what the statute contemplates? Because there is clearly in the case law the opportunity for an equitable exception when it's not the voter's fault, when it's poll worker fault. So the question, I think, is an evidentiary one for the board.
not if we're bound by the Supreme Court, though.
Well, I think the Supreme Court's ruling, I don't think necessarily excludes the proposition that if some judge of elections refused to give out secrecy envelopes, how's that the voter's fault? I think that's a separate set of facts.
You're making, I'm very sympathetic to.
Now, to go to the last point, so the missing poll worker signature issue that we were just talking about, that's not listed in this shall not be counted. It doesn't say you can't count it unless there's a signature from a judge of elections and or a minority inspector. To me, that omission is significant and important. And I think that I fully expect that that's part of the analysis. No, I take it back. I know that that's part of the analysis for the DOS guidance on this issue. They specifically noted the statutory language and said that not a reason you cannot count such a ballot. So that tells you in the absence or in the silence that you could choose to not count a ballot. Plus, it's a very obviously a poll worker error. The judge, the voter has no control whether a judge or a minority inspector signs the envelope. The voter does have arguably some control over the voter signs and maybe about the secrecy envelope if they're given one and then they don't use it. But on this signing by a judge, that could only be the failure of the election worker. So to me, that falls squarely into that equitable exception. Plus, the statutory language supports it. So to me, that's a different case than the other two. The other two, I think, may be more evidence-based, and it would be up to the members of this board whether you could infer from the facts that have been presented, and in the absence of a voter coming in and testifying, no one ever gave me a secrecy envelope, or a judge of elections coming in and say, I completely forgot to give secrecy envelopes out. My bad. We've had that kind of testimony in the past. We don't have it today. That may be important from an evidentiary standpoint on this issue. I do think that if proof is made that an election worker is responsible for the failure, that that's a different set of facts than if without such proof. I'll say that.
Yeah, you're not saying that there's a Supreme Court ruling on the third issue?
No.
Okay, so the third issue, we have a prior split ruling by this board, and there was a very long record made. And it wasn't just the poll workers. I know you disagreed with how we decided in large part because there were some ballots that we didn't have any evidence presented on. What we had presented was the process. And the process being it was a long description of how exactly a voter would come to obtain and sign a provisional ballot based on the way we have decided to print on demand provisional ballots, et cetera. Mr. Parks, is that a record that we can, because it is, 240, that we can stand on and incorporate, or do we?
I understand your question. I would say, I don't know that it would be appropriate to sort of infer facts from a prior hearing in a different election cycle here, but I do think you can each take notice the way a court would take judicial notice of the process that works in the polling place as you know it based on your own experience. I don't see any reason why that would not be information you could consider. I think you could, and I think you
Or
can.
we should make a record on the process.
Or you could ask somebody to make a record, but I do think that, you are members of the Board of Elections. You know what the process is in Delaware County for getting a provisional ballot to a voter. You know that it has to be generated on demand by a touch writer. You know that a judge of elections or someone under their supervision has to provide the outer envelope, the secrecy envelope, and the ballot that they generated on the touch writer. Voters just don't walk over to the touch writer and generate their own ballot. So that's information that and I don't think necessarily has to be proved up in painstaking detail by anybody for you to account for it in your decision.
And if I just, the non-lawyer on the board is just going to ask a little bit of clarifying question here. My understanding of what you have just told us and based on what John has said is that while the Supreme Court has ruled that there's this obligation for the voter to perform certain tasks, it does not contradict earlier and other laws that rule that voters should not be held accountable for poll worker error. So if a voter on their own failed to perform X, Y, or Z, well, then that's certainly the voters, that's voters' problem under the law, whether we agree with it or not. But if the poll worker is responsible for that error, then that Supreme Court case did not address that. And so that's
my understanding. And to me, that's the way you reasonably reconcile those decisions. And, just as a sort of a general comment, lawyers have to deal with these types of issues all the time. How do you reconcile decision A from this year from the Supreme Court, like 1975 from the Supreme Court with some other decision from 1998? Well, the general hope and desire and instruction, I would say even, is that you try to find a way to give effect to both rulings.
so I guess then it does come back to the question of, and so for my own clarity here, on our big spreadsheet here, are these the ones that say poll worker error as the reason?
Universe, unfortunately, this sheet is complete as to the McCormick campaign's objections because voters need to be notified based on those objections. But we given how late the objections finished, we ran out of time. It is not 100% complete, but categorically, Ms. Cantor has presented the objection.
The reason why I ask is just because I do notice in that category, most of them are from one precinct. And it does speak to observable pattern. I guess, what evidence are you presenting that the poll worker error was in fact poll worker error?
Again, the evidence that I was basing it on was the challenges that I watched were coming from the same 4 or 5 precincts over and over and over again. And Ms. Winterbottom's analysis of how many provisional ballots were coming from each precinct and just honestly just keeping track of what the basis was. And overwhelmingly, if a precinct made the mistake, they made it over and over and over again.
Right.
For that issue. It wasn't, we had 24 and each one had a different reason for the provisional ballot. So it was always the same issue, like the same precincts didn't check the box. The same precincts didn't have someone sign 2 and 4. the same precincts. That's all I can give you.
And we get these live reports anecdotally on election day that, so the judge so-and-so isn't doing X and we go there and try to correct it in
Exactly.
the field. So do you have, for those precincts that you observe this pattern, do you have those precincts and those corresponding ballots?
I can
for
give
us
them
know?
to you. Off the top of my head, UD 6-7 and let me get my cheat sheet.
We don't like the C word in this room, I'll just say.
Also, I guess I just want to
So-
state, hold on, to make my position clear, is that for the first category of if a voter did not sign either of the boxes, I believe that the Pennsylvania Supreme Court has ruled and it states that it's mandatory that they sign both boxes. I understand Ms. Cantor's argument towards the equities. They're free to do that. In my view, they'd be free to appeal and try to get the Supreme Court to change their mind. Justice Donahue, I think, authored the opinion there. Go to it, get them to change their mind. The second category of the no secrecy envelope, once again, the Commonwealth Court ruled this summer, that under that section that Mr. Parks read, that it's mandatory that it's there, and if it's not there, you don't count it. And I don't know that the Supreme Court took that up, but that's where the Commonwealth Court has ruled on it. And I agree that the judge or the other election official not signing it is not within that. And my view was that, hey, if the objector, it's the objector's burden to change our mind based upon what the Bureau of Election staff has decided. So if they decided it's not a count and you want to change it to a count, show me some evidence. And when we did this before, albeit with a smaller number, I think of these types of things, of objections, when we had a judge of election or the voter come in and say, yes, I did this, my vote at that time was in favor, to count it. However, if there's no evidence, that's when I voted against it. And I would do so again, because I think there are other possibilities, such as the person does, the judge, and maybe that's just the way the judge did it. The judge does get them to, hey, they weren't initially, quote, in the book, or the poll pad now. And, you have to call media or call Chester, but start filling out your provisional ballot. And for whatever reason, they found them, the person, brought back their mail-in ballot that they didn't have. I mean, there are other possibilities, that are there, and it's just all speculation. So that's what I'm saying. Without some evidence, there could have been other things. And unless Ms. Winterbottom can say that, hey, as part of our review, we guarantee that they didn't vote on the machine or that their mail-in ballot didn't come in.
I appreciate that. We definitely, I think we're applying the same standard. I want to see what the evidence is, how they're constructing this argument. And if we, I'd also like, I know we have the folks from our staff here who supervise the poll workers on election day. If we know of certain reports from that precinct that corresponds with the data they have, that's an interesting item to consider as well. If we said, hey, we got 3 calls that this judge was not giving out secrecy envelopes, and we went and halfway through the day, we went there and told them, hey, you got to do this the right way. Well, that would be compelling to me. But I do want to see what we're basing this on. I'm very sympathetic to the argument, of course, but we are bound by the law. So.
I understand. So in answer to your question, UD 26, 27, and 34 were all precincts where we were in contact with the county throughout the day, with the Joes not providing provisional ballots, not giving guidance to people. I do not have a specific 3-4, 2-6, or 2-7 where the voter said nobody gave me a secrecy envelope. But the other 2 issues were clearly throughout the day. And I know that one member of your board actually was down at 2-6 instructing people that they had to be given a provisional ballot. They couldn't turn people away because we were getting those calls throughout the day. I was also in communication with Mr. Parks and Mr. Rouse because we got that phone call so many times that we didn't, we kept sending our people from our election protection team who would go in and tell the Joe, they have to be given a provisional ballot. You don't have a choice. And if somebody from the team was standing there, they were given a provisional ballot. But I don't know how many people didn't get them.
Hear of any secrecy envelope issues? though?
I
Say,
didn't.
not giving out provisional ballots to me is a different question from an evidentiary standpoint for the issues raised right here than
I have,
not giving out provisional ballots, but not giving out secrecy envelopes with them.
I have nothing on secrecy envelopes. It wouldn't have been something that I think a voter would have known to say, wait, wasn't I supposed to get a secrecy envelope? I think strategically, it's not something the voter goes in. All they want to do is cast their ballot. If they're given a ballot, they do it. They're not looking for, a green envelope.
I was wondering if perhaps, poll observers or, someone like that observe such behavior.
Anecdotally about that.
Okay,
Nothing.
all right.
And just, we have some stuff here. If anybody has any specific information about secrecy envelopes, complaints, that would be helpful.
My only question is whether, when you retrieved the items from the different precincts, whether you logged in, how many provisional ballot envelopes were left, how many secrecy envelopes were left? Because my understanding is you gave out 50 per precinct to start the day. And then as the day went on, some precincts were saying they needed more. So anecdotally, I think internally you have that answer. Because if, we have a precinct that said we need more outer envelopes and they still returned 50 secrecy envelopes, then clearly they weren't handing out the secrecy envelopes.
Like Radnor too, for example?
That's a county issue. That's not a voter issue.
Crystal can correct me if I'm wrong, but I don't believe we did receive some calls from people who were concerned that they might run out of provisional envelopes, but I am not aware that any precinct reached 50. 50 is an extremely high number to supply, and
I do know 2 precincts had over 55. It wasn't Radnor. I don't think, was it Radnor? No. Yeah, there was like a Darby Township one that had the most.
and in those cases, I think they were issuing them in error. Were they not? Where they were giving them to inactive voters, for example.
So.
Okay.
Universe of folks who, but for this problem, would have had their vote counted. They're not on your objection, but
So
on your objection list.
in terms of our,
Just looking, is there, I'm sorry, I'm just trying to get my hands around. Are there any on here that were missing secrecy envelopes?
again, our objections are not all listed on here.
Well,
They didn't finish it.
they listed it as poll worker error. They didn't specify about the envelope. So that's the end of page 10 and the
11.
beginning of page 11.
That's only some of ours, apparently. It's
Right.
not all of ours. So in answer to your specific question, Nether Providence 6-2, Chadds Ford, Middletown 4-1, Sharon Hill Precinct 4 were all secrecy envelope issues. Oh, Ward
and
7
I'm sorry, where's
Precinct
this
Upper
from?
Darby.
I'm
This is from our
Totality of
review
their
of,
objections.
Which is not here. This
Which
is our
not
Jim's
here
list.
because
Okay.
so these are all precincts where they saw many no secrecy envelopes.
Look, I have to tell you, if there were some evidence about the secrecy envelopes, I would vote in favor of counting them because I do think that the judge controls the possession of those. So for me, it really does matter very, very importantly, whether or not we have Commonwealth court precedent that binds us on this issue. And because we don't have any direct evidence. That's the reality right now. We're not hearing direct evidence. I want to count these if we can, but without direct evidence and with a binding decision, I will feel compelled to vote against your objection and to overrule it. And Mr. Parks, is that?
Well, I would just say for the benefit of the public particularly, or non-lawyers, I think what the chairman's chairwoman is referring to with direct evidence and indirect evidence, the classic example that's always used by a judge in giving jury instructions is direct evidence would be walking outside and observing that it is raining, or having somebody come inside and tell you, I was just outside and it's raining. Indirect evidence would be watching someone come through a door dripping wet with an umbrella and shaking off the umbrella. Now, a court would tell you in a court proceeding, you could conclude that it was raining from the direct evidence. You could also conclude that somebody's lying, that it actually isn't raining and they came in and lied about that. But you could also conclude it's raining from observing the water on the umbrella and the person coming in from outside dripping wet. That's indirect evidence. And so here, a direct evidence would be testimony from a judge of election saying, I messed up. I didn't hand out secrecy envelopes. Indirect evidence could arguably be, and again, it's up to the judge, the judgment of our members of the board, but indirect evidence could be that there are 10 provisional ballots from a particular precinct and none of them had a secrecy envelope. That might tend to suggest, just like the rain on the umbrella, that there was a systematic issue that originated with the judge of elections and not the unique failings in a heck of a coincidence with 10 separate provisional ballot voters. So I think that's the example we're talking about here. And I think the chairwoman's right to hone in on that issue, because we do not have direct evidence here. And the question is there sufficient or any indirect evidence like the rain on the umbrella?
Well, I guess I'm having the same confusion with the lists and that Mr. McLean's having, and that you listed a few precincts, and I just scrolling through Jim's list, I don't see those.
Again, that's not because we didn't make the objections,
Right.
because they didn't finish compiling. They ran out of time.
Could we see those presented now so we could consider them?
Or is there
We
systemic?
do have them sorted by precinct, so if you could repeat that list, we do have the ability to pull those precincts out.
Like if there is a pattern,
So,
I just want
I
to be able
mean-
to see it or not. Right.
Why don't we don't have a motion on the table? Are we in a position, is everybody comfortable considering and voting on the voter signature not in 2 or 4, or the no judge of elections minority inspection signature issues?
Well, I'll break it down. I'll make a motion to dismiss, or what would you call it?
Overrule.
Any of the objections based upon the lack of a voter signature in either box 2 or 4.
The voter signature.
Yes,
Voter signature.
that's one we're doing first.
And that's the one where Mr. Solicitor, you say we are bound by the courts on that?
That's my view.
That's my view too.
Although
But you weren't,
the Bureau actually treated those as full counts or partial counts where there was one signature.
originally. I thought we had changed
Today.
that guidance.
No.
No, they're saying that they didn't. That's how we had.
Where's the one that, I'm sorry, you had one that you showed me where it was treated as a full count? With their signature? Or was it no address? It was no address. I
Okay,
apologize.
sorry.
No address is
No,
a totally different.
Totally different.
We tried to do that as a board.
Yeah.
So I was disappointed that we couldn't. So that is there a second to the motion? Just a
Yes,
second
I'm
for
trying to
discussion.
understand
You
what
don't
the
have-
universe is. I will second the motion, but I do want to, I'm frustrated by the confusion here.
With the list, that's fair.
With the list and what we have in front of us or not. So just to be clear, make sure I am clear on the motion that I'm prepared to second. Mr. McLean, would you please restate it?
Certainly, I would move to dismiss any objections to no counts based upon the lack of the voter's signature on the outer envelope in our boxes 2 and 4.
And so that's, okay. And that corresponds with the universe of ballots that you've objected to.
Correct.
Okay. And I will second that.
Any additional discussion? Would you like, I want to make sure that you're comfortable, any additional discussion or questions? I mean.
Yeah, I do. I do. I
Yeah.
think I think these are, I've said before, I think these requirements are onerous. I think they're designed to disenfranchise people and make it more difficult. If we have one signature and we don't have both signatures, the ultimate test for me is whether the identity of the elector is clear, whether the intent of the elector is clear, and whether the elector is in fact a qualified elector. I think everything other than that is a path to get to determination of those 3 points. The fact that we do have a binding court decision, though, And we do have the advice from our solicitor on that front. I do want to be mindful of that. And I do understand that this will be adjudicated at a venue outside of this room. But I am mindful of my responsibilities to the law and to the processes that we have. And I know that our staff works very hard to get these things right. And in this case, while I find it personally frustrating, I do understand why what our options are here. And so I just, for my own purposes, I would like to see a world where we're not bound by those, by these court orders, but we are not a court of appeals. So.
Well, if you succeed on an appeal, you'll have two people that are relatively happy about that. But at this point in time, I think maybe three. Yeah, no.
This is the law.
Right. No. I mean,
Yeah.
we don't have to, we had that long hearing about it and it was unfortunate, I think, where the court ended on that one. But, all right. So with that, all those in favor of the motion as presented by Mr. McBlain, say aye. Aye. That motion passes. The second one, I think we can talk about and potentially vote on without this, maybe another recess, is the issue of the no judge of elections and or no minority inspector signature.
Again, I do not believe that there are actually any ballots in this category. I think we did, Jim.
There are objections by the Republican
All right,
Party.
that's
on
a
this
different
front.
issue.
Okay.
Yeah. That's the other side of the same coin.
Yeah, those objections will be heard by, when they have a chance to present their evidence, of course.
Okay.
My point is simply there's nothing to vote on because there aren't any in this
Understood.
category.
Is that in that case?
Well,
Ms.
it's the other way around. They've
Right.
raised objections that they should not be counted.
Right.
We
Correct.
counted them.
Yes.
There were objections
Correct.
to the-
So from the current speaker's standpoint, there are no objections that are live as to recommended no counts that this objector thinks should be counts in this bucket. So there's no motion to make.
So you just essentially made the argument that you would make after they objected. Okay.
Exactly.
So then there's nothing to vote on that. And then we want to not yet take a vote on the secrecy envelope issue while you have an opportunity to consult about perhaps indirect evidence that you want to present or whatever it is you want to consult, but we're going to take a recess on that. And do we need the recess as well, Ms. Wagner, before you present your objections to have a process conversation? Yeah, okay.
So from Ms. Cantor's standpoint, did we deal with everything except for the
Secret envelopes.
provisional ballot envelope?
Yep.
Secrecy envelope? Okay.
Yes.
So all we've taken care of, either they've been withdrawn or we've addressed all your.
We actually made progress. I know you don't
Okay.
believe it.
Okay.
Thank you.
Thank you. All right, then we stand in recess. Well, I'm not even going to list the time. We stand in recess.
told the Harris team, we told the safety team, we told them all. So I'm just here with eggs. That's okay. I just, I feel badly. Well, just so you know, Darby said 10 out of 11 no sugar gambling. My question is, do I go through everything to count them? Because, for random sampling. So, these are all like. Day we were doing the provisional. The very first day we were doing the provisional, the 6 other Republicans all told him crazy, it was wrong. I then took a shot at it. He told me I didn't know what I was talking about. And I just took a shot at it. Because I'm a woman or because I'm a Democrat? And he just looked at me and he said, "What are you talking about?" I said, "You just told me to shut up. It's because I'm a woman or because I'm a Democrat? You don't know what you're talking about." He was just nuts. So. Yeah. Totally different. It's a lot of throwing of elbows. A lot of throwing of elbows. Yeah. Yeah, once Greg left, we had a really good. I wasn't there for Greg. The second day, it was everybody talking about how glad they were that he had to come back. Judge Nichols. Keto? Ready to go. Yep. For Darby, Ward 7, Precinct 10, had 11 provisional. These other ones are all like 1/5 of the total. So I just did a random sampling. There's like 6, 5 different things. So. They're all no secrecy. Yeah, that's all 7-10. He voted. No, he voted in. No. Right? Yeah. Yeah, he voted at 7-10. These are all 7-10 precincts. Just talking about the fact that that's all I'm talking about. You can make any other argument.
So my point is, if they're going to rule on this one, I just want people specifically on this.
Sure. No. But, okay. Yeah. This one is also, yeah. This one is just a no secrecy. This is just no secrecy.
The crowd is thinning though. All right. We're wearing you down.
That's our strategy.
Okay, folks, exciting conclusion. In 5,
4, 3, 2.
All right, good afternoon. I'd like to call back to order the provisional ballot hearing for the Delaware County Board of Elections of November 14th, 2024. Ms. Cantor.
Thank you. During the break, I had the opportunity to go through some of the provisional ballots. Specifically, I did a random sampling of about 8 different precincts. The most for the issue of the secrecy envelope. And what we learned is UD Ward 7 Precinct 10 had 11 provisional ballots, and 10 out of the 11 were no secrecy envelopes. 2 out of those 10 also were flagged for other issues, I will tell you, but they were all flagged for the no secrecy envelope. I also looked at Sharon Hill 4. There were 5 secrecy envelopes missing out of 25, so 1/5. Marple Township 1-1, we had 2 no secrecy envelopes, 2 out of 11. Glen Olden 3, we had 2 out of 10. And Upper Darby 2-6, we had 2 out of 10.
Upper Darby 6 or 6-7?
I'm sorry, 2-6.
2-6, I apologize.
What was the Sharon Hill precinct again?
4.
4. So that was just a random sampling of the no secrecy issues. And again, the most egregious was Upper Darby 710. Clearly that was poll worker.
I'm familiar with that particular precinct. It's in my neighborhood. And the judge of elections who had been serving there, we actually had a great board there for a while, but one of them recently took a job with a public agency and could no longer serve. I believe we had a brand new judge in there, and that might be a factor to consider as well.
I did not have the opportunity to go through the 750 some that we still had left because everybody was looking at different issues. But again, this is just a sampling that shows. So I thank you for that.
All right. I want to just say, I don't know that I've gotten the answer. I know your position on it. Mr. Parks, is there a Commonwealth decision that binds this board absent some showing of evidence?
I do not believe that, absent a showing of evidence, yes.
Okay.
What I think that it remains available for this board would be to, for example, consider evidence that a systematic missing secrecy envelope scenario was poll worker error, and that would arguably be factually distinguishable from the rulings that exist. But what I would ask for, first of all, the panel's already voted on this, so there's that. But second of all, I think it would be more prudent to do some careful further follow-up legal research on the question and look at this very specific question of whether these rules are being presented as utter absolutes or they are simply being presented as in the absence of evidence of poll worker failings, then the general rule is you need to have a secrecy envelope. So I think that's something we can look at quickly, but I'd prefer before I would give further legal advice on that to study that question and confirm that that's my understanding and recollection of those cases is accurate.
That would be helpful to me. I do think that just given we're going to have raised the Joe and minority inspector signature issue, to me, the secrecy envelope is actually in terms of what may be persuasive for me on the issue of the secrecy envelope is going to be the same process that is followed for provisional envelopes, provisional voting, that the Joe and minority inspector signature issue, what we decided on before but have not put out on this record. Is it possible, Mr. Allen, on the fly after a long day, would you be willing to just walk through the process for producing a provisional ballot at the precinct level?
So when the voter enters the polling place, they check in at the station with the poll pads, and the poll pads are the difference between using a phone book that only has the 400 voters in the precinct versus a contact file that has possibly all 400,000 voters, so that if someone arrives in the wrong place, the poll pad will print out a ticket and inform that voter that they need to go to Stetzer School or St. Mary's Church, whatever. But if they do belong there, or if they maybe they get that ticket for going to another location and they say, no, it's too close to 8 p.m. or no, I have to go to work and I'm not going to have a chance to return. I want to vote now. And at that point, the poll workers and the Joe's only option is to issue a provisional ballot because they're not a registered voter in that precinct. The poll pad will not accept that voter's signature. It will just say provisional is the only option, or print them a ticket to go to the right place. The other situations involve where the registration simply has been canceled, or there's a question about the voter's eligibility, or because it's a first-time voter, they have to show identification. And the poll pads list of all the different eligible forms of identifications so the voter can vote, or they asked for a mail-in ballot and they lost it and they can't remit it. Or in the case of the one gentleman who was here, he got an email from the state that said, destroy it. So if there's a question about their legal eligibility to vote that day, then their option under state and federal laws is to be able to cast a provisional ballot. So the provisional ballot just means that it can't be fed into the scanner on election day, but it will give staff the time to review and determine afterward whether that voter should have been able to vote a standard election day ballot. And I just want to make a point that, as we noted earlier, even before this hearing, about 3,000 of the 3,800 that were decided without any kind of objection are going to be fully counted, and then another 229. So, that's 32 out of 3,800. And sorry, my brain's a little math deficient right now, but that's north of 60%, 70% that are going to be counted, where the staff determined that the voter shouldn't have had to cast a provisional ballot or was eligible to cast that ballot. So that's what brings us to this day after all of the campaigns have challenged our rulings.
For whatever the reasons you've given the variety, maybe not exclusive list of reasons that someone might cast a provisional ballot, what is the actual process that happens? I know we know that. I just don't think we have it on this record.
So,
because we can take notice of it ourselves, but I wouldn't mind some explanation being put on the record.
the poll workers are trained in the election day guide. Their handbook instructs them, and our classrooms are all about teaching them how to print out a provisional ballot on the touch writer. We switched to that method rather than randomly supplying them a ridiculous number of paper ballots so that they would print it on demand. We also wanted it to be a deterrent so that they only, broke glass in case of emergency, that they didn't just start handing out provisional ballots left and right. There had to be a good reason for it and give them the reason to, wait a minute, is this person eligible to vote? So we've had that for a few elections now where they print it out on the touch writer. At the same time, the judge is trained to make sure that the voter understands that first they've got to sign box number 2, which is before they vote the provisional ballot. And then when they're done voting, they have to return and sign box number 4, which is affirming that they were eligible to cast the ballot they're about to cast. Then they have to place that ballot into a green number 10 envelope, which is about 4.5 inches by 7.5 inches roughly, or 4.5 by 9.25 rather. And they have to fold that into the secrecy envelope and place the secrecy envelope inside the larger envelope that the voter signs, and ideally, but not always, the judge and the minority inspector also sign. Those then are turned into media. Those are returned rather to media on election night at the government center. And they're among the materials that we separate out from the ballot bag to the V drives, to the return sheet, to the pay sheet for the poll workers, the oath paperwork, all the other items that come in the green tote. which carries a variety of supplies. So then Crystal's team looks to find all of those large provisional ballot envelopes that are a compilation of all the envelopes, or should be, and were in 99% of the precincts. I think her staff told me today that 2 precincts did not use this envelope, but otherwise returned their provisional envelopes. So this also is signed by the judge and the minority inspector, or at least should be, and is in most all cases. And this contains the provisional envelopes in most cases that the Crystal's team then begins to not open, but process by pulling up the screenshots in the Shure system, and to compare that against what reason the judge or minority inspector have or have not checked to see if that voter's eligible, or to see if that voter's even registered to vote in Delaware County.
Thank you. All right, the reason I asked, it may be obvious to some, especially the lawyers in the room, but the reason I asked Mr. Allen to explain that is that in a past vote on this issue, and consistent with the Department of State guidance that is new, that was not at the time of the vote, we had a split vote on this issue, and I voted in favor, along with Mr. Alberts, of counting those provisional ballots that lacked the judge of election and or minority inspector signature, because we did have some evidence, as Mr. McBlain indicated, some direct voter evidence, but there were a couple cases where we didn't have direct evidence. What we had is, as Mr. Parks noted, we can take judicial notice of, but we've now also put it on the record, at least in summary form, the fact that provisional ballots they're not randomly at the precinct anymore. There's not the opportunity to just fill them out. There's a long and tedious, because I have to tell you, I'm sure Pam gets this from the judges of election, minority inspectors. It's a very tedious process. Takes a long time when the judges of election are very active, otherwise at their precincts, to print out a provisional envelope, take all the steps. They have imperfections, and then they return it. And sometimes they even return it with imperfections in terms of signatures. But that's how we get to that point. And then on the flip side is the fact that Ms. Winterbottom and her team do checks to see if the person's double voted, tried to sneak, do some fraud, or maybe, well, that's really what we care about here. And those checks are designed to make sure that that is not allowed to happen, that somebody doesn't get to vote twice, or doesn't get to vote when they're not a qualified voter in this election, in this precinct, or if they're a qualified voter in a different precinct, then their ballot's restricted in terms of what's counted based on the appropriate precinct that they should have voted in. So I ask that because we do have some now what I would call indirect evidence of at least one precinct. And I think it's only one precinct. I don't know that I'm not a mathematician. I can't with confidence, the Sharon Hill 4 or 5 out of 25, I'm a little open to, but for 710, Upper Darby 710, 10 out of 11, when the judge of elections controls the access to secrecy ballots, that does concern me, that we have a systemic indirect evidence of judges' failure to assist the voters, and really a problem that's not the voters, but one that should be placed on the judge of elections for not carrying out their duty, in which case I'll wait for Mr. Parks, and we don't have to decide right this second, because one, Ms. Magner may want to speak to it, two, my colleagues may want to speak to it, if it's sufficient to have that type of evidence to say, in that case, we're going to look at the Commonwealth binding court ruling, but we're going to look at it differently because we have some evidence of a systemic judge or minority inspector failure. I'm certainly open to it.
Yes, and we're looking at that real time right now. So we might have some, some additional information. But again, there has been a motion that's been voted on already in front of this board. So, we would have to deal with the provisional issue of the record having been supplemented, and whether there would be.
Which motion are you saying has been voted on? We didn't vote on the signature, the secrecy envelope one. We
voted on the remainder.
Okay.
Okay. Thank you.
Okay, but Mr. Yeah.
Sure. Let me just point out, and I understand, and I don't want to be the hard-hearted one where I'm trying to disenfranchise people, but again, again, our appellate courts don't do us any favors by issuing, multiple rulings within a month or two before the election, where you have to kind of parse through it. But I did, I think I gave to Mr. Parks the case, the Walsh case, which is the latest Supreme Court case that talks about, section, that subsection 5, small II, a provisional ballot shall not be counted if. And it interprets, that was the one with the signatures, but basically the holding there, and I'd certainly refer to Mr. Parks if he disagrees with me, is that, if it's in that, if it's listed there, it says a provisional ballot shall not be counted if, and it's one of those conditions. And the court goes through and it indicates, the other side of the argument, just as we've heard today, is, courts generally are against disenfranchisement. We want to interpret these rules liberally, but it talks about that, this is absolute language, so it must be followed. And I just want to point out in regards to another case that came around, and Ms. Cantor had cited to it, in re canvass of provisional ballots in the 2024 primary election that dealt with a legislative district, a primary battle where it was only a handful of votes separated the candidates, and there were different challenges to provisional ballots. There, the court cites an in re Allegheny provisional ballots in the 2020 general election Commonwealth Court case. And it says the Allegheny County Court expounded, assuming there was evidence of election officials providing misleading advice to these voters, as in the case before this court, it indicates, this court nonetheless would be unable to excuse the defects in the ballot based on the Pennsylvania Supreme Court precedent that, because our General Assembly pronounced a bright line rule couched in strong admonitory terms, we are not free to disregard the explicit legislative direction based on equitable considerations. And that cites to the Pennsylvania Supreme Court case of in re nomination petition of Gazzardi from 2014, where a candidate was not excused from filing timely financial statements through principles of equity, even if the election office provided him with misleading information. In other words, where the legislature has attached a specific consequence to particular actions or omissions, the Pennsylvania courts may not mitigate the legislatively prescribed outcome through recourse to equity. And this holds true even where, as here, election officials allegedly provided erroneous advice and the recipient relies on that advice. So that's, my view. It's that it's laudatory for us to look to the equitable principles and want to try to count it all. But, as I've said from the day one that I've been here, I think, that's where public loses confidence if we do not follow the rules that are set forth. And while that argument is understandable, and I understand it's being used, even during the break, I saw on Twitter where another county, and the commissioner there said, in Bucks County said, I know this is against the law, but I'm going to do it because I think it's the right thing. That's laudatory, but here is not the right place to fight that fight. Go up and talk to the Supreme Court about that, who, again, just, as recently as this fall, looked at those things. So that's why, and I don't doubt that perhaps in Upper Darby 710, where 11 out of the 12 or whatever it was, that it might have been the error of the judge of election or whomever, but we don't know that. And nonetheless, I think we're constrained by the law to just follow it. And if it's an important principle, it may be pursued. That's why they you keep going back to the Supreme Court to change their mind, when it's adequate, when it's right to do so. So that's just my 2 cents again.
Yeah, no. And so, I mean, I think that is the basis for us having, at least for me, having been reluctant, but voted to overrule the objections to the voter signature, not into for again, is, and that what you're saying is, even if we had evidence the other decision says we can't take that into consideration. I think that actually might have happened in one of those hearings where we had to tell a voter that they weren't going to, it was, again, very sad to me. I believe it would have been sad to you.
So again, I'm here talking about
I know, but what you're saying is the same thing, is that the secrecy envelope is called out specifically.
the secrecy.
And that
envelope is called
therefore,
out
if there's a
specifically.
decision, equitable evidence can't over.
The lack of signature from the judge of election, that's a different story. I don't believe.
No, the lack of
I read-
signature, sorry, on 2 and 4 by the voter is also specifically called out.
That's, yeah.
So that's the argument, but Manly's going to be allowed a little more courtesy to, I don't know, Ms. Wagner, if you need to try to make any argument on that, given your, there's an advocate here for the law that's very good, but you're welcome to if you'd like to.
If I may just very briefly.
Bless you.
So I want to make sure I understand what we're talking about now. We're talking about the naked ballot,
Correct. Sorry, I may have been.
the naked.
You're not with me, John. We're not having a mind meld. It's too late in the day. Okay. I thought I heard your argument saying, well, my argument originally for having to vote in favor, contrary to what I'd want to vote on the voter signature for is because we lost in Judge Whelan's court and then perhaps also in the Supreme Court based on the fact that it was explicitly called out. And then I think after we applied that ruling, I could be wrong, Crystal, Ms. Winterbaum and Manley's nodding, I think nodded before that I wasn't wrong, is that there were voters who came in and tried to present equitable evidence and that we still had to vote consistent with the judge's ruling.
Right.
And then I think you're making an analogous argument that the secrecy envelope is specifically called out.
Well, I thought,
Am I wrong?
I thought that when we recessed, the issue before the board at that point was the last group of objections from Ms. Cantor, that were based on the secrecy envelope.
Mhm.
And she took a look at some of those and came back and gave us some of the statistical evidence. And that we would deal, are we dealing with the secrecy envelope?
We are. I was just making an analogy.
Okay.
But the analogy being, you're saying we have a Commonwealth Court ruling that says that the secrecy envelopes have to be used or they can't be counted. And that you're saying that the ruling that you just read from indicates that if it's explicitly called out as a requirement in the statute, that equitable concerns cannot override that requirement.
Right, for the secrecy envelope.
Correct.
Right, okay, that's what I'm.
And so we'll see if Mr. Parks has a different view. I'm guessing Ms. Wagner will have a similar, maybe more nuanced add to this conversation.
But are we moving on to the?
No, she's being asked if she wants to speak about the secrecy envelopes.
And I will just briefly, geez, Mr. McBlain did take most of my my arguments, so I appreciate that. All I would say is, in summary, our position, I just want to make sure our position is on the record regarding that, is that it has been dealt with by not only the Court of Common Pleas, but I do believe the appellate courts as well. I know Mr. McBlain said that, but I don't think that there's any room for other interpretations in this particular statute, just that particular line. And what Ms. Cantor provided, she said herself, was a mere sampling. And I don't think a mere sampling is enough when you're trying to determine whether there's enough indirect or circumstantial evidence to actually allow that objection. So I just don't believe that there's enough. And I do believe that you have to look directly to the statute. When the statute says the provisional ballot envelope does not contain a secrecy envelope, the provisional ballot shall not be counted. And again, it shall not be counted. So as a result of that, I do believe that we have to go directly to the statute, and I don't believe there's any room for any other interpretation.
Can I ask a quick question just as follow-up? I understand that we may have different facts here, but just in a hypothetical scenario, what happens where a judge of elections specifically decides that they don't like provisional ballots, so they're not going to hand out secrecy envelopes, and along the way manages to take a bunch of provisional ballots that would otherwise, let's say they're mail ballot voters who got their mail ballot and decided they wanted to vote in person and didn't bring their mail ballot. So they're kind of an easy case, generally speaking. But the judge of elections is like, I don't feel like giving out the secrecy envelopes. In that scenario, or your view is that equitable principles don't save those ballots. Maybe the judge gets prosecuted for some election crime, but the ballots don't count. Do I understand?
I'm not saying that at all, with all due respect.
Well, so what's the legal distinction between that and
With all
what
due
you're
respect, I
saying?
don't think it's a fair question. And the reason is because that evidence is not before us today. It's not a situation that we're talking about.
Well,
That would
but
also-
it's
if I-
very common to sort of suss out where the line is by creating hypotheticals and then figuring out how the line, whether the principle applies in all scenarios or in some scenarios, and what's the distinction? That's what
I
I'm trying to-
understand. What I'm saying is that that's certainly not before us today, and that's not the question that I think this board has to determine. I believe that situation is completely different in the sense that that would be something nefarious, obviously. I don't think that we have any evidence of anything really at this point, other than the fact that the secrecy ballots were not where they were supposed to be. So I think that's a very case by case situation, and I think that would be dealt with completely differently because it would be a nefarious situation.
Thank you, Ms. Wagner.
Okay.
All right, I think if you still need time, Mr. Perks, we don't need to move to that, and then you might get stuck back up here.
No, I think we can proceed. As Mr. McBlain noted from the Commonwealth Court case, the court does say there's no room for equitable considerations. Now, I will say that I would probably, if I were on the Commonwealth Court, have dissented from such a ruling because there are Pennsylvania Supreme Court cases that establish the poll worker error cannot be the reason you disenfranchise a voter. And the case that the Commonwealth Court cited for the proposition was not even a ballot case. It was a case that had nothing to do with ballots. It had to do with, filing campaign finance forms, which is a whole different can of worms than somebody's vote. So I'm not sure that's a particularly compelling authority, but that's not the reality. The reality is that the Commonwealth Court, whether on kind of a weak authority or not, has made a pronouncement that equities don't matter. I do appreciate that I put an outlandish hypothetical out just now, but the point of that is to say if the equities don't matter, then the equities don't matter. If the answer to that scenario I just laid out is, well, the equities sometimes matter, then we're in the world where I think, honestly, if I were wearing a robe, we should be in, which is let's look at the evidence and the equities. I think that's almost always the law in American jurisprudence is that the equities matter. But the reality is that the Pennsylvania Commonwealth Court did not say that. So Mr. McBlain is correct. I would dissent from such a ruling, but that's not my job here. My job is to, try to counsel you to follow the law such as it is written. And, I think the law is from the Commonwealth Court, maybe perhaps poorly reasoned, maybe not something that I think is well, should be the rule, but that's what the court did say. So equities are not to be considered apparently in Pennsylvania unless and until you get a different ruling from a higher court saying you should consider them.
Well,
Judge Wolf would agree with you.
He dissented,
His
yeah.
dissent.
I don't know if Ms. Wagner appreciated your hypothetical. And as you have many former prosecutors in this room, I would love to think that there was some sort of crime fraud exception to the judge.
Without going back through, Madam Chair, I think there is a reference in there too, except for fraud, at some point. So that would address the hypothetical.
Good. I'm glad to hear it because there should be.
Yeah.
I just for the record, to the extent it matters, I would have been inclined absent the prior court ruling, particularly the point about the equities, to have counted the UD 710 votes if they were not otherwise excluded. I understood some of them were excluded on secondary bases, but from being counted based on the fact that there seemed to be a systemic pattern of no secrecy envelopes used in that particular precinct. But I'm ready to vote, and I feel compelled to follow the court's decision.
Well, if I didn't, I would make a motion that the cache of cases where the challenge was to the lack of a secrecy envelope that the objection be upheld and dismissed or held. I guess I keep getting that wrong. I'm sorry.
No, I don't know. Don't confuse me. It's too tough to do.
Yeah. Overruled. I'm sorry.
I can second that if you want. Do you have any? I'll second that motion.
Thank you, because I declined to second that motion. And I'll just say a few words about that. I don't usually cast the symbolic protest vote on the board. I think I try to get to the conclusion that we need to get to. And I understand and I respect absolutely my colleagues' reasons for voting the way they're voting. And I'm not even saying they're wrong, given the advice from our solicitor and the current state of the law. I will say, however, that any judge that says there's no room for equitable consideration, why do we even have courts? Why are you serving as a judge if there's no room for equitable consideration? I think that's an egregious thing to say in a ruling. I think that based on Jim's explanation of the process, my understanding of the process, based on the pattern we see in the 710, based on the anecdotal observations of anyone who's observed a judge of elections walk a voter through the provisional ballot process, I think, there's clearly a barrier to enfranchisement at several points along the line that I think need to be considered when we're talking about someone's right to vote. I think the preponderance of evidence, certainly in the 710, is that there was a poll worker error. And if there are Supreme Court rulings that say people should not be held accountable for poll worker errors, then it's sort of irrelevant to me, to my thinking. Again, not an attorney. I respect that you guys know this stuff better than I do. It's sort of irrelevant to me that a Commonwealth Court opinion says something different that contradicts this overriding principle that a Supreme Court case is upheld. So for my purposes, and specifically with Manley's bad faith example, I mean, what is the protection, right, from a judge of election who doesn't get caught doing something nefarious, but is slyly doing something nefarious? If we can observe this indirect evidence and make logical, reasonable conclusions from the patterns of what we're seeing, and if we cannot make equitable considerations, again, why do we even have a legal system if we're not trying to get equitable considerations? What's the point? So that's my reason, and totally respect where you guys are coming from. I get it, but I'm just going to have to dissent on this one.
All right, and before I vote, we do have in the room our poll worker trainer. I would appreciate if any of these precincts that had no secret C ballot supplied, including particularly UD 710, if the workers would be retrained and we can find a way to reemphasize. You do a great job at training poll workers, so we're not talking about a lot of ballots here, but just reemphasize with all poll workers the need, if they do provisional ballots, to use a secrecy envelope, because I think this is an unfortunate result, and maybe it'll get appealed, and maybe you'll prevail, Ms. Cantor. So all those in favor of the motion as presented by Mr. McBlain, say aye. Aye. All those who dissent, say aye.
Nice try. No.
All right, that motion passes 2-1. Thank you. All right, Ms. Wagner.
Thank you. I'll be as brief as possible. I believe that we have been able to establish really that I only have a couple arguments left to make after resolving many of these. I first want, just because I feel compelled to do so, thank Mr. Allen, Ms. Winterbottom, and the rest of the Election Bureau and voter registration. This has been a very, very long week. It's been very tiring, but I know it's about tenfold for them. So I appreciate all of their work. And I certainly appreciate all that you're doing today. I did have an opportunity to go over with Ms. Winterbottom the ballots that we found that were not signed in box 2 and 4. And I believe at this point they've been changed to, the recommendation's been changed to no count. And I would believe that would be consistent with your vote that you took earlier. I just want to confirm that before I move on.
If it would be helpful to you to put those changes and recommendation on the record, we could do that now, so that, if you don't mind. Thank you, Ms. Winterbottom.
We do have 2 that we incorrectly marked full count. Box 2 was not signed on one, and I think the other one was box 2 as well. Yes. That I have changed to a no count on both of those. And then there was one more that
there was some additional.
Crystal, can you just put the 2 voter names on the record so we have that?
Yes. This one. So one was Aston 2, that name was Ryan, last name Renigio. And the other one was Upper Darby 5-1, and that was Courtney, last name Antoine.
And then during the process, and by the way, just to pause for a second, you all, the team is wonderful. We're the best team in the world. I've said it a million times. So I thank you, Ms. Wagner, for your kind words. But I also have been really impressed by both both objecting parties that are here today in the presentation and the collaboration and trying to get through a long process. It's my understanding that during the course of that review with Ms. Wagner, you did review a non-signed in box 2 affidavit where there was a very, very specific note from the judge of election?
Yeah, so it was, box 2 was signed by the voter. Box 4, in the box 4 box, it looks like the Joe wrote a note, left before signature, attempted to reach by phone and text. And then the voter's name is printed under that with the date. And then the judge of elections taped this to that provisional ballot, if you want me to read.
Did you read that? Because I think we're going to go into exactly the equitable situation that we've just discussed and the problems with it.
So it says, I, Louis D. Montesor, Judge of Elections at HT 42, failed to ensure that Nathaniel Francis Luzzi's provisional ballot was signed in Section 4. I submit he should not be penalized for my mistake. He signed the stub inside. He signed the affidavit. I witnessed he go through every step in the process until the end when my attention was pulled away and I missed it. I urge you to allow him to cure it. If not, accept the envelope as is. Signed, Louis D. Montesor, Joe HT 42.
So he's putting in writing that this defect is due to his error as a poll worker.
That's what,
So we have written testimony from this poll worker that his error caused this defect.
that is what the Judge of Elections of Haverford 42, yes.
And we're recommending that for a count then, or?
We recommend it as a full count,
Yeah.
since it shows that it wasn't the voters' error. And it also looked like there was a signature in box 4, so I'm not sure if that's what we saw too. Thinking it was a signature as well. But it is not Nathaniel's signature in box 4.
It's a notation from the judge of elections referring to the attachment.
Okay.
I will say that the case where Judge Wayland adjudicated the ruling with 2 signatures, I think there were 2 or 3 ballots in question, and none of them had involved any question of a judge sort of acknowledging or a poll worker acknowledging a failure by the poll worker. They were just missing signatures with no further evidence. So that question did not get presented in Judge Wayland's adjudication.
Because I don't want to make myself a hypocrite here with the concerns about equities. Okay. So that is a ballot that you are objecting to, Ms. Wagner?
Yes, that challenge stands.
Do you have any questions for anybody about that ballot? I know.
I guess it's a little more difficult when you actually hear it, you get the confession from but I guess I'll remain consistent. I just gave a big speech about, what the Commonwealth Court is ruling and whatnot. So I guess I'm kind of bound for that, even though it's obviously this is more personally presented.
Yeah, I mean, I think it speaks to the absolute ridiculousness of that argument by the Commonwealth Court. I mean, here it's very clearly, this person, we have before us the opportunity to disenfranchise a person due to an error of a poll worker. So again, I would point out that the state Supreme Court has ruled that voters should not be held responsible for errors by poll workers. The fact that the Commonwealth Court has ruled something else, last time I checked, the state Supreme Court is higher than the Commonwealth Court. Again, I'm not an attorney, but that's my position here, and it was my position in the last vote. It will not change in this instance. In fact, I think my point is reinforced. We have, disenfranchising a voter under the color of law. This is an act of injustice.
We don't have to go so far because I feel like Mr. Parks threw me a bone and gave me a little bit of wiggle room, but recognizing the black I might take on that for the positions, Judge Whalen, I don't know that Judge Whalen would have ruled the same way on that.
I would hope not.
I would hope not too. Okay, so do we have a motion to overrule, dismiss the objection by Ms. Wagner to this particular ballot whose name is?
Nathaniel Luzzi, L-U-Z-I.
So moved.
I'll second that. All those in favor say aye.
Aye.
All those opposed? Okay. That motion passes 2-1.
Okay, and actually, based on that, that's actually a great start to why I believe a missing judge of elections and a minority inspector signature is a problem. That was actually a great leeway or into that. The fact is that I understand that this is a little bit different in terms of the fact that this is the poll workers who need to sign it, but I think it's important that they sign it. And I think that that's why, those signatures are there. What's the point of having those boxes to have those signatures if they're not that important? They have to sign after they vote in front of the judge of election, correct?
Yes.
Right, in front of the judge of election and in front of the minority inspector, so that everybody is satisfied that the vote is done appropriately. I think without those signatures, it can lead to mistakes, to, in some instances, fraud. I'm not saying in many, but in some instances, it can lead to fraud and to confusion. So that's why those signatures are there. There has to be a point for them. And if you look under 8.42, under 3050, it talks about the fact that those signatures should be there. And there's a reason the law has provided in the statute that that's part of the provisional ballot. And I think it's a very important part of the provisional ballot. And I do believe that further than that, that's how we keep order within the provisional ballots in the voting booths or at the polls. I think the board is aware and understands my position on that. So I don't think I need to go any further, but I'm confident that you understand that. The other two issues that I again will be brief on these.
Should we vote on those just to do it systematically?
These are the ones.
These are ones that are missing a judge of election or minority inspection signature on the outer, the provisional envelope.
Or both.
Or both, one or both. Okay, is there a motion to overrule the objection of Ms. Wagner on?
So moved.
Okay, I second that. Okay, any further discussion?
I'll just indicate again, this is not one of the categories that under 5 subsection 2 where provisional ballots shall now be counted if. However, before we just simply, in my mind, before we just simply dismiss it, to be consistent with what I did before, I think we should hear evidence, from that judge of election or from the voter that, like there was presented, with the last one relating to the person didn't sign, that, there was some explanation for it. Maybe I just missed it, but I know Mr. Parks referred to there was some directive or recommendation from the Department of State, who sometimes opinion I respect and sometimes not. But was that based on any court case, or I'm aware of any court case that has dealt with this issue?
So no, the Department of State recommendation was principally based, and I'm just recalling it, so there may have been a footnote citing a case as well, but the principal basis was the structure of the statute and the fact that the statutory provision that we've been referring to earlier, the 5 Romanet 2, which talks about the reasons you cannot count a provisional ballot, does not list as one of those reasons the lack of a signature from either or both poll worker.
That's all.
I just got a blast from them. That's the way I know about it. Okay, sorry.
Yeah, so the distinction, a minor procedural defect versus a statutory defect is what you're saying, right?
Well, it's still required by statute that they're supposed to sign. It's just there's not the death penalty,
right.
to it that's attached to the other ones.
I should hope not. Some rather egregious penalty.
Qualified session.
All right,
No.
well, so we have the
Alright.
motion on the floor. It's been moved and seconded.
Okay, all those in favor.
Can
say
I just
aye.
add real
Yeah, sure.
quickly, just based on that? I just do want to remind the board that I understand where that guidance is coming from, and I understand the Secretary of the Commonwealth sent that out, but it of course is not binding on this board. So, and it is part of the statute. So I just want to make that clear.
No, and in fairness, I'm not persuaded or not persuaded by that. I'm persuaded by the process and how, the fact that we don't have a crime fraud here of the
Understood.
voter and it's a mistake, but so all the reasons that we said about the process. So all those in favor, say aye.
Aye.
All those who dissent, say nay.
Nay.
All right, that motion passes 2-1. Now, Ms. Wagner, I think we only ruled on, oh, no, okay, never mind. Sorry. All the rest of the, stop, I'm going to stop. Go to your next one, please.
The last, I think, challenge we have that has not been resolved is the wrong precinct.
Okay, is that because the affidavit incomplete, but we have the signature? Has that been?
I'm sorry, you're correct. The lack of info in box 1 or 2, I can move on to next if that's, okay.
Oh, I have that as separate from the affidavit incomplete that have signature.
I have grouped them all together, that
Okay,
the affidavit
that's
not complete or something incomplete or missing information is
Gotcha.
all the same issue. And I'm going to argue that basically under the same part of the statute that I argued the last one from, which was the 8.42, which is again where they put in there, the current address, that's part of the statute that they, want to see. And it's obviously on the ballot. Again, why is it on there if we don't need it, if it's not necessary? So for all of those reasons, I do believe that the ballot should be filled out completely. And again, I believe that the statute provides for that. So I will leave that to the board at this point.
Yeah.
And what's the factual basis of this one? I'm sorry.
Oh, no, that's fair. Let's, there's,
It's on page 9. Its items
But if you have a
286,
provisional ballot,
287, and
it's-
288.
It's a lot. It's not just them. Yeah, it's.
yeah, it's that the signatures are there in 2 and 4, but other information is not completed in boxes 1 and 2.
Correct. If you,
Like this, see how box doesn't have the address.
Okay.
Jim, if you want, I can look.
So the voter omitted the address in either box,
Correct.
in box 2 or box 3.
Or box 1.
Box.
Box
She's
1.
not
box-
counting, you're not objecting to box 3.
No, it's mainly just box 1 and 2.
And did Ms. Winterbottom, did your crew confirm that they live in that precinct where they cast it? Are they registered to vote in that precinct where it was cast?
There might be some part, I don't know, if we deem them all full counts or partial counts. I believe they're full counts.
So there's 3 of these?
No, there's a lot of these.
Yeah, the short row is going to be the ballot and you can pull off the ballots.
But I think that we're not sure that they're all, there's the possibility that some were not done in the right precinct. So the partial counts.
Okay.
Which
So
is,
I guess let's take it one step. Ms. Winterbottom, did we confirm for the people that they didn't put their address? Did we confirm that they're registered to vote?
Yes,
Okay.
yes.
And for the ones that are registered to vote, and we check their address to ensure if they were in that precinct, it's a full count?
Correct. Or if they weren't in that precinct, if it was a partial count or if everything was in common.
Okay. And none of the ones that are subject to the ones here today are the people registered out of county.
No, that would have been a no count.
And on this one, I mean, just as this example that was pulled out, we have the voter information is filled out with their name. They give their date of birth. They've given their phone number and email. They filled out section 3, the current address where the voter lives, and they have not filled out section 2, just the address part of it. They have signed in section 2 and they have signed in section 4. The information they would have filled out in section 2 is included in section 3, which is somewhat redundant apart from the voter municipality and voter county. But we've confirmed that this person is in fact registered and eligible to vote at this address, that this person is a registered qualified elector. There's
Mr.
no
Howard,
confusion here.
if I could
right?
just tell you, that's probably a bad example because we weren't objecting when box 3 is for when you live at a different place than you're registered at.
Understood. Thank you. Thank you for the clarity.
Yeah.
I was like, this makes no sense.
Box 2 is where you're actually registered and the box 3 is used for when you don't currently live at that address.
And Mr. Mitterbottom, I'm done with this ballot. I don't want to just lay it down.
So if I could just ask Mr. Wagner, it's, not having the address is not one of the reasons to not count it. what would be the argument that, again, our overall arching issue is, do we want to make sure that this person didn't vote somewhere else or whatever? What would be the scenario that I need to worry about that because of the address isn't there?
Understood. And it's really all of it. As I said, it's also box one. Sometimes there is missing information such as date of birth and that kind of thing. I would submit that really the issue is just verifying who the voter is and making sure the information matches. And that frankly, that Ms. Winterbottom can do her job afterwards to ensure that that address is to that particular voter. Again, I don't need to continue to harp on this issue. I think you guys understand, where I'm coming from with it, but it goes to, having completed the ballot is really what it is.
Thank you. And I think, to the point that Ms. Wagner raised, Ms. Winterbottom has in fact done the work and confirmed to her satisfaction and that these people are registered qualified electors. So, I do understand where you're coming from, but I think I disagree with the conclusion.
Understood.
I think we did a reevaluation of that envelope to see if we could make any changes at some point because it is such a cumbersome envelope for people to follow all the different boxes. And we tried to highlight things and we tried to do so many things to make it so that things are completed.
We very much did so. We employed color, which led to a much higher success rate in terms of the various signatures. That's why I did the math, by the way, since earlier I couldn't do the math. That's why we have an 80% acceptance rate. And I suspect the ones that aren't, they're just totally not qualified to vote,
Right.
In Delaware County, or they're not qualified by some other legal issue. But still, it's a long day. We had more voters cast ballots in person on this election day than at either 2016 or 2020. So I can see where, where they're getting distracted and pulled in four different directions, like all of us, quite frankly, were on election day, that they're going to miss a line here or a line there. And when the voter fills out an address on one section, maybe they shrug and say, I've already provided that address, so I don't need to provide it over here. So there are a number of barriers. And I would add to Mr. McBlain's remarks about, the place to settle this is possibly another court case, as well as with the legislature. You can make a valid case with a lot of these things, the secrecy envelope, the date,
that's where it all exists with, and I'm prepared, Madam Chair, that again, this category where I understand why the objection was raised to begin with, but Ms. Winterbottom has confirmed that these folks are registered in that precinct and their full counts are not registered in the precinct and are only partial counts, and none of them live outside the county, which is really the only prohibition regarding address there. So I'd be prepared to move for this category of challenges to deny the objection and uphold the counts.
Is there a second?
I'll second that.
All those in favor say aye.
Aye.
That motion passes. Thank you.
The last real, objection we have that has not been resolved is the wrong precinct issue. And I want to make it clear that when it came to wrong precinct, we only objected if we felt it was willful. And I can give you some examples. Ones we objected to where they actually wrote on the ballot that they went to school in Aston and lived in Chester. So they refused to go to Chester to vote and voted in Aston because that's where their college was. Things like that I felt were willful. We also saw some where it was actually written on there, refused to go to actual or correct polling location. The only other time we objected of feeling that it was willful was when the polling places were so far apart from each other that there's no way they could have felt that that was appropriate, or felt that that it wasn't unknowing, and that it wasn't unwilling. So that's the only time we did it. I want to make that clear. I understand there's mistakes and that sometimes, people have to vote in other places, and I understand that they've been issued as partial counts, but The section that I'm arguing under that is 7A 3, or I guess I. In the event that the Board of Elections determined based on evidentiary record that the individual intentionally and willfully cast a provisional ballot in an election district in which the individual was not eligible to vote, the ballot shall not be counted. And again, I'm just submitting that as a group of votes. And those were the reasons that we did it. And I, as an officer of the court, can tell you I did not object to any of the others that were close, or I felt it was actually a mistake. In that position, it was just either written that it was willful and intentional, or that they were that far apart.
How many are at issue here?
See.
28.
Yeah.
That into the spreadsheet. I don't know if there were some dual where you objected to one
28.
item and the wrong
No.
precinct, but I think those last 28 in the spreadsheet are all wrong precinct.
That's correct. It's those 28.
And in that statute, they mean by election district, they really mean the precinct assigned to them.
Mhm.
Now, this is like the other sides of the coin, Ms. Wagner, because what we have here is then indirect evidence not favoring the voter.
Correct. Yeah, that the voter was willful and was intentional.
Right, but we don't I mean, you could argue it, but we don't, there could be other explanations. I'm disabled and I had to leave and I went to the wrong place, whatever it is. I don't know. It's indirect evidence. Right?
100%.
Yeah, I mean,
understand.
it's always, I mean, I think anytime you're arguing intent and will is always inherently indirect. You're not the person, you can't know their will, just from a philosophical standpoint. But so just, would you consider it to be intentional and willful for someone, let's say they, their car broke down on the way back from their job in Delaware. They're driving through Delaware County. It's 7:50. They vote in East Lansdowne. They just pull over at a polling place in, I don't know, in Ridley on their way home and say, I'm running late. What can I do? What can I do? And they said, well, you can vote provisional. And those are very far apart, right? I mean, I would not think that's intentional and willful. I think that would be panic. That would be attempting, to vote and then perhaps being rightfully told by the judge of elections, well, you can have a provisional ballot because we have to give provisional ballots to everyone. And fundamentally, I think, I mean, the issue here is, this person is entitled to vote in all the races we're recommending them to count the vote. It seems like a stretch to say that just because they're far apart, it's intentional and willful. Wouldn't you agree?
No, I do not agree.
Or maybe they used to live there and they just got confused about where they were registered and they showed up at the wrong place.
That I think is what it's supposed to cover.
Right.
I mean, that, I would just to jump in, your first scenario where the person knows that I live in Radnor, but I'm stuck in Ridley and I go to vote in Ridley, that is prohibited by the statute. I think that's pretty clear. If they, thought that they were had just moved to Radnor and thought that they were still registered in Ridley and voted in Ridley, that I think is permissible. I guess these 28 aren't segregated out or anything.
By students versus other things?
They're not.
No, I mean, there are all kinds of different precincts and I recognize that many of these, if not all of them, are not on college campuses or anything like that.
I didn't say they were all students. I said that was
No,
one.
I was saying that-
person says, I'm going to go to my
Right,
school.
that
I
was
can
just-
understand.
that was just one
It's a little
example.
different. Oh, so fair enough. That's the first time you've had to say it today, though. That's amazing. Okay.
That's, again, that was just one example. But the rest, and again, I did it so far apart, for a reason, that we only challenged or objected to the ones that were that far apart. I even would suggest that if you go to Radnor, you think, and you're registered in Ridley, you could tell them, I just moved and those things need to be rectified, and I think that's the purpose of part of the statute is for that reason.
I mean, I do think people are often ignorant of the process. I mean, I know there are states where you can just go to voting centers and vote, and they might be a new resident, just not know these rules. So I do think there's a lot of, I don't think the geographic proximity one is a particularly strong argument for me. I am very interested in the ones where people wrote stuff on the ballot. So I don't know if you say you actually have some written evidence or direct evidence to that effect. be interested in seeing those, but I don't know if we've identified those.
Well, I mean, they're I have not pulled them out, but they are the last 28 on the spreadsheet.
Try to have people throw stuff at us because it's 25. I don't know if it takes 5 minutes and pull those 28 out and say.
If that would help the two of you with your decisions, I think I know where I'm going, but I'm happy to have that recess.
Yeah, I mean-
All right, let's actually declare it 5 minutes though.
Yeah.
And we'll stand in recess for 5 minutes. Thank you. That's just to motivate.
Thank you. I do believe you have almost all of them there that we were discussing, which are the wrong precincts that we objected to. I'm going to renew my argument. First of all, I do think you've separated them out to the ones who actually wrote that they intentionally went to another polling booth. So I would suggest that's actually direct evidence that they did that. The other ones that are up there, I'm still going to make the same argument for, although maybe not direct evidence, but it says on a lot of them, wrong precinct, voting in wrong polling location. To me, that says they knew that, that, you know, they're voting in the wrong location and continue to do so anyway. And then the other ones that don't have writing on it, again, I did solely for location issues, but they were so far apart.
And would you like to put those in the record?
Sure. I mean, so what I would do, Madam Chair, is that in my mind, if the judge of election or the election official that filled out their portion of the provisional ballot noted affirmatively that the voter understood that they were not at the right place and did not wish to go to the right place, I would move to sustain the objection and not count those votes pursuant to that section 3050 subsection 7(3).
7B3.
7 what?
B. 7(3), yes,
Right.
okay.
And those are voters Tonique Layrich, Danielle Freeman, Markea Johnson, Stephanie Bernard, Michael Kelly, and Shamil Green. And I'll pass those to the other board members. I went through them during the break and separated them out.
I've reviewed them. I think you may have as well.
The remaining,
Bless you.
the remaining ones that are in this batch of challenges, I have reviewed on the provisional ballots, and here there is no indication that the voter affirmatively did, would not go to the correct polling place, or there's no explanation. And I did look at the addresses of where they were either registered and where they voted. And I don't believe there was anything that was so egregious that we were using the Ridley Radnor distinction. I didn't see anything like that in here.
It wasn't Upper Darby Concord, but that's kind of the same thing.
Yeah. There might have, but again, to me, I would want for me to vote to not count their vote. To be consistent with all the other votes that I've taken, I would want to see some evidence that there was an affirmative knowledge that they were not supposed to be where they were, but still demanded to cast a provisional ballot.
I think, certainly, I think we are probably of one mind on that category where there is no, I do have it looks like we have a comment from one of our staff members that might be important.
Dawn Chandler is the poll report.
Can you pick her up? If it's up to Sean and the court reporter if they can hear.
So you say your last name?
Lairdson. Lairdson.
We told the Joes to write if they were in the wrong precinct, so it would alert Crystal's group, the voter reg, why that poll worker, why that voter was voting provisionally.
Thank you. Yeah, I think we caught we made a distinction here when we separated these two piles that I think makes some sense. And I get where Sean's coming from here, where if it just said wrong location, it's just simply a statement of fact. That doesn't say anything to intent or will. But we do have this other section here of ballots where I'll just read them off. Where did not want to travel to her precinct, wrong location, would not go there. Voting in Aston, Ward 2 because goes to college in Aston, but lived and registered in Darby Township 1, did not want to go to her precinct, did not want to go to his precinct, did not want to travel to her precinct. So all of these comments do speak to some idea of intent or will. However, in my observation, and they appear to be written by, like, as you say, by the poll worker, not by the voter. And so, and while the, poll workers are signing off on that, and I believe they're faithfully reporting what they believe to be true, we don't have the opportunity in this forum today to question, to ask more, like, how do you know they didn't want to travel to their precinct? Did they say it explicitly? Are you inferring it? Was there language difficulties? There's room for doubt here. And for me, it's certainly more substantial evidence than we've seen in most cases today. So I do appreciate the hard work and diligence and the seriousness of this. But for me, I do think there's doubt here that I can't say I can determine definitely the intent and will of the voter based on someone else telling me what they believe the voter's intent or will was. I think it is evidence, but I don't think it's compelling evidence, personally.
Yeah. All right. The one I would like to pause on. First of all, it is interesting, Ms. Lairdson, that several of them are done by the same person. So I don't know if they took direction to heart in a different way, but there's a couple others that are by others. The one in the, I do think there's some indicia of willfulness. I think you have to have some evidence of willfulness to override a voter that otherwise checks out. So I'm really struggling with this. But the one that I think doesn't belong in this category is that because goes to college in Aston, which is where they voted, but also and registered in Darby Township. That one, I don't know that it's sufficient to say that they'd understood that they could. It doesn't say they refused to go to Darby. The other ones say they refused to. That they understood, well, they should have, that they can't go where they're currently laying their head at night and vote if it's in the same county. So that one gives me some pause. And then the others all say did not want to go to his precinct. Interestingly, that there is, most of them are from the same person, but there slipped in at least one that isn't the same judge of elections. Let me just see if they're the same.
I think I saw.
Yeah, Lansdowne one is 4, and then that one's an Upper Darby one.
Yeah, it looks like 4 of them are from Lansdowne 1, and then this one is from Upper Darby 7. Oh, it's Upper Darby 7-3. That's my neighbor.
I am trying to maintain my consistency as much as possible, and the consistency is trying to get votes to count. That's what's the most important. If they're qualified to vote in our county and they vote or they try to vote, is to try to get them to count, because. But meaning the burden is sort of more on you if you're trying to get them not to count, in my mind. That said, I don't know if we've given Ms. Wagner an opportunity to comment. I don't know if Ms. Kenter, you're not obligated to comment, but since you're here, if you do want to comment on this, I'll tell you that I am struggling with the 5, that there's an indication of willfulness given the statutory language. I don't consider the school one to be the same because it's not written in the same language of willfulness. And I am in agreement with Mr. McLean, and I think also Mr. Alberts on the other category.
I would ask the court to think about, or ask the panel to think about, since you're not judges, is that we don't know anything about these voters. Are they working shifts? Are they healthcare workers? Where they don't have the ability to run across the county to go home. They didn't make a good plan. They voted. Being told that they needed to go to another precinct and choosing not to doesn't necessarily make them willfully refusing to do what needs to be done. They have the right to vote in the county of Delaware. Everybody has the right to vote. It's a willful failure, and like they told you, or they came and told the court, or they told the panel that I didn't want to go to Chester because I don't like my precinct because they're mean to me. Is that willful, or is that self-preservation? I mean, I don't know what it is, but we have no testimony from any of these people.
Right.
Just like I had nobody coming in to testify as to whether they had their secrecy ballot or not. It's the same issue. Just because a Joe says I told somebody something doesn't make it true. It doesn't. And I don't think that we can accept that and just move forward and say, well, we're going to disenfranchise. How many of the 28? Was that 8?
5.
5 of the 28, simply because a Joe wrote instructions as what he or she thought were the instructions, which is to give a reason why they weren't going to where they should go. I mean, everybody wanted to encourage people to vote in the right precinct so that they would be voting for the right House representative, because that was the only race at issue. But that shouldn't disenfranchise them from voting for all of the other state offices.
Yeah, there are two, I don't think the burden should necessarily be on the voter, but in this case, I do want to make sure it's clear that all of these 5 would have received notice from us that their vote count had been challenged.
Yes.
Okay. And I mean, the struggle I have is that Joe is, they are like the judge and jury of their precinct. And we do empower them with a lot of authority to report crime, to count votes, to turn people away, to kick people out, because we have to do it that way. It's a localized election. And so the Joe, in this case, 2 different Joes have indicated that some willfulness on part of the voter. That's what I'm struggling with.
I understand, but again, the Joe's not supposed to turn somebody away. They have to give someone a provisional ballot.
Right. They did not though.
They did, yeah. Oh, did not turn some.
Sorry, I didn't mean to interrupt. Go ahead.
Yeah, they did not turn them away. They gave them the provisional ballot. And that was what they were supposed to do, but it doesn't mean that the voters vote for statewide offices and the president shouldn't be counted because they were lawfully allowed to vote in the county of Delaware.
But that's not what the statute requires. The statute indicates that if they were aware that they're not in the correct precinct, then their vote does not count.
But we don't know why they chose to. We
Doesn't
don't have them
matter
here.
why.
Again, you and I are going to argue about the moon and the sun and the stars, I'm afraid. But again, I believe that this is not a mandatory denial. I believe it's a, let's see which way this works for us. The state is not saying you must not count these provisional ballots.
No, you're wrong. The state does specifically say that. And I don't mean to argue with you, Ms. Cantor, but the law says specifically that. I mean, you can't look at the law and, where it says you shall not count it, and you say, I think you can, because this person didn't want to go to Chester to vote.
Well, again, that voter didn't come in and say, I chose not to go to Chester to vote. That's the difference. If the voter had said, and the voter wrote on their ballot and signed it saying, I specifically chose to vote here because I didn't want to go to Chester to vote, that would be direct knowledge that the voter made a conscious decision and didn't do it. That's the difference. This isn't the voter saying it, it's the Joe.
And you've brought judges of election in to testify on, for petitions that you filed either for or against things in the past. And you asked us to believe the judge of election in
Nobody
those
here
circumstances.
brought anybody in to testify one way or the other. That is my point. Exactly. There is no direct evidence because no one brought it. Not us, not the Republicans, not the outliers. Nobody brought in direct evidence to this hearing. Okay.
Right. But we do have the guy that walked in with his raincoat wet and his umbrella wet.
Yeah.
Did?
But we have not had a chance to interview the gentleman who walked in with it. I mean, I think the issue for me is what information, I mean, I've been a judge of elections. So one of the reasons I'm on this board, I spent 8 years working inside polling places as a minority inspector and a judge of elections. It's a customer service job. It's not always easy. You're dealing with language barriers, difficulty with cognitive understanding of what's going on. What did this person know they were voting in the wrong precinct? They said, no, this is where I voted. Were they refusing to listen to the judge of elections? Is that willful and intentionally voting in the wrong place? Did the judge of election get to finish explaining what the situation was before they insisted on getting a provisional ballot? These are the kind of questions I would like to be able to ask the voter or the judge. And so, like I say, it's more evidence we see in many of these cases, but I just don't think it's definitive evidence. I don't think it's compelling evidence. I think it by far requires more attention than some of the things that have come before us in the past 2 weeks. But I do think it is wrong location, would not go there because would not go there because their car wasn't working, because they didn't have any gas left in the tank, because it was so late that by the time they got there, the polls would have closed. We don't know what time was this ballot completed? I don't have the answer to these questions.
I don't know if I need to hear from you yet, Ms. Swagger. Just Ms. Larson, if you wouldn't mind, what was the direction that was given to, are you flicking things at me? I want to go home.
Was because there is no box there where they select a reason for wrong precinct. They were just supposed to write wrong precinct.
Okay, there's no direction that said you got to ask them to go, and if they do or they don't.
We said encourage them to go to the correct precinct. If they get angry, allow them to worry, or they're running out of time. I used the example of, they're on their way to work, or it's 5 of 8, they're not gonna be able to get to the correct precinct. Allow them to vote provisionally.
And Mr. Parks, just in terms of the empowerment of the Joe and the expectations on the Joe and these type of circumstances, I'd love to understand from a legal perspective where you think I've made the argument that they're sort of the judge and jury of their
Yeah,
polls.
that's a different issue, though. They're the judge and jury with respect to things like challenges that come before them, with respect to determining where the 10-foot rule is in the polling place. Here, I think they're effectively a witness that you could choose to believe or not believe based on, how much weight you accord the information and, in light of the circumstances. So, I think ultimately the issue is a weight of the evidence issue, and the standard you're trying to determine is whether and I'm reading now from the statutory provision, based on the evidentiary record, that the individual intentionally and willfully cast a provisional ballot. So note that the statutory language is not intentionally or willfully or only intentionally, but intentionally and willfully. To me, that suggests some sort of mental understanding that I'm in the wrong place and I'm voting here, notwithstanding the fact that somebody told me I'm in the wrong place. So the question for this board, assuming that that is the way you each individually read that language, which, look, I can tell you what I think it means as a lawyer, but you have to make your own determination. And beyond that, you would then have to determine if the evidence presented to you is sufficient to meet the intentional and willful standards set forth in the statute. I will say that, election records are important records, and these are people that take oaths to uphold the election code, and we rely on the information they provide to this board to function in many, many ways. Whether that, that does not inherently mean that depending on the way the language is worded, at least to me, depending on the way the language is worded, is this an inference the judge drew? Is this based on something the voter said to them? I mean, I think that these are the types of questions that you can consider as you sit to determine if this evidence presented is sufficient. The fact that the judge did not physically come in here, I think, is maybe less important in the sense that they are election officials sworn to do their duty, and they submit a lot of paperwork to us and don't come in here and swear on it every single time. Sure. But whether the information they presented was sufficient, and if you had concerns, the fact that you couldn't ask them questions could factor into your determination on the evidentiary record and whether it's sufficient.
If I may just to add to that, first of all, I think the words intentionally and willfully mean the same thing, frankly. But there's a reason that you
Words matter, Miss.
I know, I heard. There's a reason that you separated them, and I understand your position on the others. But the ones that you've kept and the ones that, you separated from the rest of them, I do believe show a willful intent, because they say would not, or refuse, whatever, the 5 of them say. And that's a good indication. And we do have to remind ourselves that, as I think was alluded to, these JOEs are elected. They are elected officials. And I think it's indicated on the rest of them that all they say is wrong location. They actually went into some detail on those. So that's why I would ask that you sustain the objection on those.
Yeah, well, I'm obviously the problem here that's keeping us all from our dinners and going home. But I ultimately here's where I land. I do try to count when in the circumstances voters who have qualified in other ways, every other way to be to vote. I don't like to rule against them. I think that Ms. Lairdton's points, although not dispositive of anything, the indication was they're supposed to handwrite in wrong location. And I do think that given that 4 of them are from the same voter, that they handwrote in wrong location and they added a little commentary.
You mean the same judge of elections?
Judge could be that they went a little further with what they were asked to do, but doesn't necessarily go so far as to show that the voter had full intention and willfulness to vote in the wrong location. So I think that to me, that's the part is if we had not asked them to write this in here, anything in here about wrong location, then I would hope that our judges would indicate somewhere. I don't know if in our training we say, if someone's being difficult and problematic, to write a note to explain it or anything like that. I don't know if we do that, but us affirmatively inserting language that they're supposed to say, but in giving them direction to add it, means to me that they thought that they were compelled to add something. Doesn't necessarily mean we understand the circumstances of the voter, their aggressiveness towards voting in the wrong district or not. So ultimately, I could talk myself out of it. I almost was with you, Ms. Wagner, but that one piece that we said, write something in here, and the same judge did it 4 out of the 5 times is to me an indication that our directions may have caused part of this issue.
And I understand that, but I think that's actually, you're almost using my words that I would use to argue why I think those are different, because the others do say wrong location, right? And they did add extra information there, and maybe that was
Nothing.
What's that?
Most of them say nothing.
A lot of them say nothing. Yeah, and I agree. And I told you why I objected to those. But I do think in terms of those, I think it's 5 left. There isn't additional information, and maybe that JOE was doing his due diligence to ask why they were in the wrong precinct. That's what that says to me.
But there's also no nuance between the voters. It's the exact same phrase for each one, and there had to be different nuances between 4 different voters as to why they might not go to a location. I think there's 2. The point is, even if we don't know, there's too many permutations that.
Well, I understand, but I don't think the statute requires you to know why. It's just saying that they did it. So.
But I think you've made a really good argument and made this really difficult. And I don't know if I persuaded Mr. McBlain to put this in this category or this category, the student, because we will take 2 votes.
Yeah.
The question is whether or not you think that that's different in terms of willfulness. I've at least argued it in this forum that is different because it's more of a student who says, I'm voting where I go to school.
Well, let me then withdraw my motion and I'll make a different motion. I'll move that we sustain the objection to the provisional ballot of Markia Johnson and not count her vote.
I don't think that's going to see.
It fails for lack of a
Fails for lack of a second. So do we have a motion to overrule the objection to Markia Johnson? The provisional ballot.
Well, first, in the sake of efficiency, I'll move to overrule the objection to all the ballots.
I think he may want to, Mr. McLean may want to put on the record the nuanced view that he's taking.
Fair enough. I move to overrule that.
And you could put these two.
I move to overrule. Why don't we, the one we have consent on, why don't we be something?
No, make the motion to overrule.
Okay, all right. Then I make the motion to overrule the objection to all 5 of the ballots where the additional notation was made as described.
There's 6. They're.
Because now we've added the one in here.
Oh,
the
right.
student, yeah.
All right, so yes, then the motion includes Markia Johnson, Danielle Freeman, Tonique Lariche, Shamil Green, Michael Kelly, and Stephanie Bernard.
Okay, I second that motion. Any further discussion? All those in favor say aye.
Aye.
All those opposed say nay.
Nay.
Okay, that motion passes 2-1. Now we have this. Is there a motion to overrule the objection of Ms. Wagner to the remaining, and I'll read them into the record. Is that, I think, Amari Gibbs, Jacob Santagello, Ashley Schotten, Thomas Gibbons, Rocco Innovale, Nadia Moss, Ray Har, Maureen Harris, Alexander Molitor, Emily Walker, Harry Weldon, Amy Hoyt, Diana Ruzat, Rania Moore, Tamir Begarabov, Mohammed Imran, Nahid Akhtar, Heather Childress, Dylan Green, and Unique Gaines.
Just so you know, there's also Jerry Gibson, who we weren't able to locate.
And
The provisional ballot itself was not able to locate, but it is part of that.
If that, we don't know whether it had a notation or not, though. Either way, at this point, it doesn't matter.
No, but I can tell you that it doesn't matter.
All right, and thank you for that addition. So with that amendment to the motion, is there a second?
Second.
All those in favor say aye. Aye. That motion passes. Thank you, Ms. Wagner.
With that, everything else I think has either been resolved or can be considered withdrawn.
Okay, thank you so much. I do think, Ms. Lairdson, there's been lots of little things here for our constant improvement, and this is definitely one. If there's a direction that they should add the wrong location, we may need to put some information around the issue of willfulness.
I want to make a point of mentioning that this is a state designed form that is purchased through William Penn Printing by all 67 counties. So this is not some kind of mistake or omission on the part of our staff. We were actually trying to make this work, just trying to establish that for the record.
There was definitely no, I don't think anybody, including Ms. Wagner, was saying that anybody was trying to do anything wrong by asking for notations. Yeah.
Secondly, and this is more a question for the board and our solicitor, do we need to go through the formality of authorizing
Yes.
all of the recommendations that Ms. Winterbottom and her staff prepared on all of the items not discussed today, the full counts, partial counts, and no counts, including the items that were initially objected to, but the objections were withdrawn. I would like to ask for the board to consider a motion to that effect.
That's our goal to do, right?
There needs to be a catch-all motion with respect to all other recommendations made by voter registration staff through Ms. Winterbottom. And then while I'm just have the floor for a moment, I will say that there is a 48-hour appeal or 2-day appeal time associated with an appeal of the rulings of this board. And the ballot should not be touched in the meantime because, you know, we need to give people the opportunity to decide whether to appeal this ruling or not. So they'll stay segregated until the appeal time runs. If at such point the appeal time runs and there is no further court action, then we can proceed to, process those ballots in accordance with the board's rulings. And then if there is a court action, then they need to stay segregated pending the outcome of the ruling by the court.
So I will move to affirm the adjudications of all the provisional ballots not subject to objections here today.
Second.
All right. I don't think we need further discussion, do we? So all those in favor say aye. Aye. That motion passes.
One question though, since what we did was overrule and all the other ones which were going to be adjudicated, what we did was overrule objections, right?
Every one.
We did not vote to authorize moving forward with those ballots if like we did. Should we?
That's probably technically accurate. And the way the motion was framed a moment ago, it was all other ballots. And really, I think the effect of the collective effect of the rulings by the board here today is to affirm the recommended adjudications of every, as updated with, because there were a couple that got changed, but as updated, I think every single adjudication was of the voter registration team would be affirmed based on the ruling. So I think that you could modify the motion to affirm all of the recommended adjudications.
I'd like to make such a motion if that would just be as a good housekeeping move.
So we're going to override, are we overriding all of our other rulings with this?
But you don't override. The rulings were to reject objections. But then I think that as suggestions have been made to take the.
He said all other.
Yeah, we need to authorize Crystal to move forward once the appeal process is complete. Okay. Right.
So
that's what.
I just want to be sure that we're all on the same page. So we're going to process all of the items that were not subject to any of the objections immediately or as soon as possible. And then we're going to hold all of these items for 2 calendar days or 2 business days. Big difference.
It's not 2 calendar days. If I understand the timing of the court schedule, and then I understand this is unfortunate from an election administration standpoint, but if the second day is a weekend, I believe, or a holiday, then the deadline goes to the following Monday. So although it's technically 2 days, in the statute, I believe that actually works out because today is Thursday, that the deadline for these appeals would be Monday.
Okay, so that, just to be clear, also, that means we're not going to be able to certify on Thursday, the 21st.
Well, that, we could certify subject to, subject to the outcome of in any case. And Now, keep in mind that, there may not be appeals filed. If there aren't.
Okay,
Or that
so
that's-
can we schedule the certification for the 21st under the assumption that there won't be any appeals, and then possibly have to postpone it if there are such appeals?
I think
Well, we won't be completed counting. If we're holding these up and preventing them from being counted,
right.
there's got to be a 5-day air gap, as I understand it, between the completion of the last ballot being counted and the certification. So the 21st won't be next week.
Yeah, I mean, I
Now
think that
looking at
that's,
25th.
yeah, I think that the practical reality, it could have been maybe the 22nd, because that's the 5th day after next Monday. But the reality is I expect lawsuits will be initiated here, frankly, and that we will be in holding pattern with respect to that. And then there'll probably be guidance from the Department of State, because this is going to affect many, many, many counties. I can't imagine there won't be litigation across the Commonwealth on this issue. And the certification issue will not be unique to Delaware County, is my suspicion.
Okay, to continue down this rabbit hole. If there's going to be litigation and we don't have a decision, we're still required by law to certify 20 days within Election Day, meaning the 25th of November, the Monday before Thanksgiving.
But there is a
So-
legal exception for matters that are unable to be certified because of pending legal proceedings. So I think that would apply here. And in fact, when we've had specific recounts, for example, or things like that, or pending legal proceedings in the past that were limited to a particular race, we had certified the results as to all other races and then not certified and waited for the court's ruling, at which point then we were able to proceed to certify. And we've done that a couple different times in the last few years. So I think that's the correct procedure.
Is what you're saying that if we don't have the answer till the end of business day Monday, and then you need time to count the 732, any of them that is not subject to appeal, that that'll take some time to finish, and that the 25th will not be the required breathing window between the two dates?
No, the 21st won't be.
Right, the 21st won't be.
And for what it's worth, it's not going to be 700 and some, because I think
It's fewer
many of
than-
those have been
Yeah,
withdrawn.
249. I was reminded by counsel for both sides were withdrawn, so it's less than that 700 number.
And not all may be appealed.
Well, and the one blanket appeal.
Right.
That one may be appealed.
That's true.
That's true.
Okay.
That's true.
So how can we,
And look, frankly, I don't think that it is appropriate or serves anyone's interests beyond that to be opening these things in the meantime and figuring out what the results are and then having this become a results-oriented fiasco. I think that these things need to stay in their envelopes so that people are making legal decisions and not outcome-driven decisions.
Well, to dig even deeper into this rabbit hole, there is the possibility that we can process those.
not add them in like we did before, yeah.
And segregate those as.
But that's what point I'm just making. First of all, I believe the statute specifically mandates that this board segregate them.
Okay.
Second of all, I just don't think it's a good idea to know what the results are in any subset of these, because then you end up with some outcome-driven decision-making and potentially at least, whereas now we've got pure legal and factual questions that aren't muddied with knowing who the votes are for.
Fair enough.
Yeah, well, all right, well, let's just cover the off on, let's.
The cleanup motion still.
The cleanup motion to count all provisional ballot, to follow the recommendation of Ms. Winterbottom and the voter registration department on all provisional ballots.
Barring any appeals and.
Barring any appeals, and then also recognizing the amendments that she made to those recommendations.
Well, not even barring any appeals. Your decision is to
Yeah.
follow her recommendation. If there are appeals, they may be, but that doesn't change your decision.
That's correct. I want to make sure that she's,
Well, everything but the ones that were challenged. Go ahead, make the
we
motion. I
we
understand.
didn't authorize her to count them. We
Only the.
we overruled the objections. The ones that your motion authorized her to go ahead and count the rest. The ones that we ruled on, we just ruled on the objection. We didn't authorize her to go ahead and count the way your most recent motion did.
Correct. His motion was to affirm the adjudication, and I think that's the appropriate motion. I don't know that a motion could be, I mean, administratively, Mr. Allen's already authorized to supervise the processing subject to the legal restrictions I just mentioned. So I don't think a separate motion has to be made for that. What the motion is are you going to, is the board adopting her recommendations? That motion was made as to subset of these.
Yeah.
Needs to be made as to the rest, or the existing motion that was made in the past needs to be effectively superseded by a more all-inclusive motion, but it doesn't have to tell anybody to go do anything with those results because Mr. Allen is already empowered with that power.
Look how
As our
exhausted
director.
we are that we can't get this straight. These poor people have been sitting here while we can't get this straight. All right, well, just in case, is there a motion to adopt the recommendations of Ms. Winterbottom and voter registration on all ballots that were adjudicated today? Would that cover it, Mr. Parks?
That would be the companion to the motion that's already been made and passed by Mr. McBlain. Yes.
So moved.
Okay, I'll second it. You're not sure if it's necessary. Does it matter?
Well, but then, that would negate I mean, there were things I disagreed with where I would have overturned it. I mean, so I don't agree with those, but I agree with the rest of it. And I thought by us adjudicating it here today, that gave direction as to what to count, and what not to count.
I think that's a fair argument, but the idea was to just make sure that we had a clear, decision at the end that was all encompassing. Yeah, I agree that rejecting the challenge is implicitly and silently adopting the recommendation. But at each point, there wasn't reject the challenge and adopt the recommendation. That could have been perhaps a more refined motion in each instance throughout the day. All we had was reject the challenge. We didn't have and also adopt the recommendation. So I'm just trying to dot the I and cross.
Why don't we do it that way so that Mr. McBlain doesn't have to agree with the
Can we
county?
reset?
And I don't think Ms. Wood would be offended if you vote no. I think we understand your position. Yeah.
I mean, go ahead. If I could, Madam Chair, ask Mr. Evans to restate the motion. I'm sorry.
Yeah, so I vote to affirm the recommendations of the voter registration office as amended.
And as adjudicated.
And
as adjudicated by this board.
I'll second.
Okay, all those in favor say aye.
Aye.
All right, that motion passes. All right,
We're getting,
signaled that we can't stop yet.
we have a finger up.
You did, you shot it at me.
Thank you. Sorry about that.
I was offended.
Well, it's almost 6 o'clock. Should we order some pizzas for the room or?
In the old days, people would go down to the lawyer's bar. The old bar days.
Is that what they mean? by
After a long
bar?
trial, after a long trial day ends. What?
Today's special
We're-
is meatballs and
I
ravioli.
think we're not, I hope I'm.
believe we can proceed. Madam Chair, I believe we can proceed.
Hold on. Live in 3, 2.
We're returning to our parties the second.
Second?
All those in favor say aye.
Aye.
And we can use it on here.
All right, clear.